There must be. Yes, ladies and gentlemen, you are most welcome and good morning to each one of us who is already online. We are set for our webinar this morning where we are going to be talking about the international trade in times of crisis, lessons and opportunities for lawyers. Our speakers are already in the room. We are at the ULS house, and we believe that the people that are already online are able to hear us loud and clear. We have quite a number of participants who have already joined. Please let us know in the chat. We'll just have some online etiquette when you join the webinar and you have anything that you want to communicate either to the speakers or to the technical team. You can just go to the chat and then you are able to post your communication there in the chat. The technical team is going to be able to pick it up, but also if it's a question that is going to be going to a particular speaker, we'll be able to raise it to that particular speaker. We are only having 3 speakers since we only have half a day here. We were set to start at 9. It's already 9 and we've started. We believe that by 1 or before 1, we will be done, this being a Friday. Ladies and gentlemen, we have quite very interesting speakers lined up for us, as you could have seen on the flyer. When it comes to these matters of international trade, cross-border practice, they need no introduction because their work and their reputation precedes them. But I just want to take quite keen interest. We have very, very interesting participants who have already joined the webinar. I see His Worship, Mr. Frank Nigel Thembi is online. Thank you so much for joining, sir. I see quite reputable advocates who are already online. I believe these are people who don't join webinars to get CLE points, even though the webinar has CLE points that it's attracting. But I see people who are interested in this area of practice already online. Thank you so much for joining. Our program is going to be a very short one. It's going to be a very, very short one, and I just want to lay it out for us so that we have a clear expectation of what to expect through the short time that we are going to be interacting with our speakers this morning. As we set out to begin our webinar this morning, which is a webinar on international trade in times of crisis, lessons and opportunities for lawyers. We will have an introduction. I'll just be introducing our speakers this morning, but later each speaker has a slot where they are going to be talking to us. Since this is a CLE program, we are going to be having lots of learning. We'll be having opening remarks from a ULS council member or a person from the secretariat. Then we will have our first speaker who is going to be making a presentation for about 45 minutes. We'll have our first speaker. We'll have a Q&A in case some questions come through during the presentation of that particular speaker. We are happy to put the questions to them. But because of the energy already in the room, each of the speakers that we have, as I'll be introducing them shortly, will be weighing in on each of the respective subjects or each of the respective topics. Among our topics, we'll be reflecting on the 25 years of ESC law, the 25 years of the East African Community Law. What are the core doctrines and domestic application concerns or aspects that we need to pick on? And we'll have a very prominent practitioner in this area, Mr. Emmanuel Sebijo Semanda, who will be speaking to us on that particular topic. In no particular order still, we will have a discussion on the African Continental Free Trade Area, the AFCFTA. Every time people are mentioning that acronym, if you're not used to it, you may not hear certain letters being sounded, but it is the AFCFTA, the African Continental Free Trade Area. What is in need for lawyers? As Africa, or as the African continent, we have signed on to an agreement that is intended to facilitate trade across Africa. It is bigger than just the trading blocks of the East African community. It's bigger than the COMESA. It's bigger than the SADC. It's bigger than the ECOWAS. So the bigger question this morning, which Mr. Ivan Ojakol is going to be helping us reflect on, is what is in it for the lawyers. And if any questions come through during his presentation, we will be able to pick them up in the Q&A. We'll be able to pick them up in the plenary and the Q&A. And we'll be also reflecting on the subject of trade wars, trade disruptions, and the end of AGOA and the new international trade order. Trade wars, trade disruptions, and the end of the AGOA and the new international trade order. But this is not just an academic session. We want to interrogate what is in it for lawyers. We are looking for business left and right. The third quarter of the year is coming to an end in this month of September. So the bigger question is, as you enter into the fourth quarter and final quarter of the year, just before an election season, how can you unlock more business? And with the trade wars that are happening and the things that are causing these trade wars, which Mabel is going to be talking to us about, we want to find out what is in need for lawyers. My job this morning is really simple. As the moderator, my name is Laston Gulume. I work with the Africa Law Practice Office in Uganda, which is ALP Advocates Uganda. And in East Africa, ALP, we have offices in South Sudan, in Juba. We have offices in Nairobi in Kenya, and we have offices in Dar es Salaam in Tanzania. I am privileged to be serving as the head of ALP Uganda, and this morning I have people who are much wiser than me who will be discussing the difficult topics. Mine is to take us through the program and to moderate it. Every difficult question that you have, please send it through. The people who feed AI with the answers that you may be looking for are already here. They are already here and they are able to answer those questions directly. As we are aware that in the advent of artificial intelligence, sometimes the answers that we get seem to be incomplete. So please, we want to encourage you quickly in the chat as we are going through the different presentations. We have attendees who are joining the call. More people are joining the call, and it's quite already very exciting. It's an interesting topic this morning because it is outside the usual practice that we learn in law school and also that we interact with every day. But yet, when you're talking about aspects of international trade, it affects our very daily life. Today, when you look at the kind of laws that we are passing in our country, we have to be cognizant of the community law. How does the community law, such as the East African community laws, affect our domestic law? You will also find that if you're trading and you're dealing with the taxman, you're going to be interacting with laws such as the East African Customs Management Act, that if you're, importing, exporting any goods within East Africa to another East African country, and you want to get your transaction to be treated a better way, you'll deal with something such as the rules of origin. You may be advising a business and it wants to relocate. This is an actual case that happened. You want to relocate from one partner state to set up manufacturing elsewhere, but when you bring your goods which have been manufactured there, you'll be faced with certain tariffs which are not favorable, and they will be running to you as a lawyer to advise, okay, how do I take the advantage of the East African common market under the Common Market Protocol, which is under the ESC Treaty, and so on and so forth. So these are interesting discussions as we'll be talking about and reflecting on the 25 years of ESC law. The East African Community as a trading bloc, interestingly, is benchmarked many times as a model trading bloc, but locally here, all the people who are practicing within this region, we still have so much value to unlock, and we'll be privileged to have this topic discussed by Mr. Emmanuel Sebijo, who will be taking us through the reflection on those 25 years. And still in no particular order of our speakers, we'll at a later stage also have a discussion on the African Continental Free Trade Area. What are the opportunities for lawyers? My brother and friend Ivan Ojakol is going to be discussing this one. He's quite very passionate about this area of practice. And while some of us are still caught up in a lot of court litigation circles, these people are making money which everyone should be able to tap into. And our final topic of discussion, because we don't have the entire day, yet this is something which you don't discuss really in one day at all, will be the trade wars, trade disruptions, and the end of AGOA, and a new international trade order, what is in need for lawyers. Ladies and gentlemen, still about online etiquette, you are at liberty to go to the chat to post any expectations, and also because we are using online technology to network, it would be good to post in the chat where you're logged in from, probably also the firm that you're working with, so that we are able to pick up the people that are online. If you log in with your device and it's not showing your full name and you want people to know your full name for purposes of networking, it would be nice that you can rename. You can click on your name and you rename yourself so that we are able to know your full name. So you can say a quick hello in the chat. If there are people you're seeing online you've not seen in a long time, you are also at liberty, ladies and gentlemen, to be able to say a quick hello to them in the chat. But we also have a Q&A. In the webinar, there is a part of the Q&A, which if you have a particular question that you want to address either to a particular speaker, or if you want me to pick up as the moderator, you can go to the Q&A and you post your question there. The moderators will also be able to pick up, or rather the speakers will also be able to pick up some of those questions, but I will be in place to pick up all the questions that will be coming through in the Q&A so that our speakers are able to respond to them. In this webinar, at later stage where we are having the plenary and you want to ask a question, you should be able to raise your hand. Now, if you want to raise your hand, there is, if you're using your computer, there is a particular icon of React. It has a heart. When you click on it, it will give you the different options. If you want to clap virtually, you can clap virtually. If you want to give a thumbs up, you can give a thumbs up. If you want to, maybe there is a joke that has been cracked, it is possible that some of our speakers with their sense of humor, yes, I see already people practicing the clapping. It is good that you learned how to clap virtually. Thank you so much. It means that someone is hearing us. But if you want to raise your hand, that's what I was leading to. Later, when you want to be given an opportunity to unmute and speak, you will have to raise your hand by going to that icon of React. And when you raise your hand, we will be privileged to pick up that, and then the technical team will be able to give you rights to unmute and be able to ask your question. Now, should you find yourself that you want to unmute and ask a question, still about online etiquette, we'll request that you are in a quiet place. We'll request that you're in a quiet place so that as you're asking your question, since the webinar is being recorded, we are able to hear you very well. Secondly, you will keep your video off, preferably, so that we are able to hear you well, but also just in case the background or where you're seated may not be for the public eye, so that we only are able to pick your question and we are able to have it put to the panelists and they are able to respond to it. Other than that, the panel is fully constituted, and from my extreme right, I have Mr. Emmanuel Sebijo, who needs no introduction in this area. I have been at different fora and platforms with him, very, very knowledgeable on this issue of the East African community law. Mr. Emmanuel Sebijo, in his line of work, he's not only practicing this area of law, but even in the areas where he is leading, he is practically a very good go-to authority in this area of practice. Mr. Emmanuel Sebijo Semanda, it's a very great privilege to have you, my brother, and it's good to see you this morning at the ULS house. Second to Mr. Emmanuel Sebijo is Ivan Ojakol, who is a partner at Matrix Advocates. Mr. Ivan Ojakol, from his very wealthy years of experience, he loves to act humble, that he has not practiced for long, but when they are telling, on this webinar, the young lawyers were supposed to pay 70,000. Ivan, it's my submission that you're not a young lawyer, so so when you play very humble and his body can deceive you because he keeps very fit and healthy, but he's been around for quite some years. And he's very passionate, not just in having the necessary academic qualifications in this area, but he breathes and talks this issue of integration. And the moment we had the African Continental Free Trade Area Agreement signed, I looked out for who are the people who are making noise about this thing. And every time you would search, whether on X, now those X posts, I think many still call them Twitter posts, but they are made on X. When you go on X, when you go on all these platforms, you'll find his name there. So we'll be privileged to have you this morning, and we'll be privileged that we invoke quite a discussion on how we can unlock value around the area of the practice area of the African Continental Free Trade Area. Ladies and gentlemen, first, the Radical New Bar did this intentionally, that the only lady on the panel feels very comfortable. Yes, this is how they have balanced the gender, that the lady on the panel is well protected, but her experience combined in this room is very, very wealthy. Mabel Kisaka is the managing partner of Mesa Advocates. Earlier in the morning, before we went online, we were chatting on very interesting aspects. And I believe there will be great takeaways as she's taking us through her presentation this morning on the trade wars. Someone may think the wars that are happening in Ukraine, the wars that are happening in Israel, they don't affect us, they don't affect our trade, until you see certain prices going up and you say, me, I'm not a trader, I am not exporting, but yet, because you are a lawyer, and you're advising people who are trading, you're advising people who are transacting, there are going to be great takeaways of what is in need for the lawyers as sanctions are coming from US and tariffs are being imposed here and there to force certain negotiations by the Trump administration. AGOA is expected to be expiring. It is a bit in limbo as whether there will be an extension, but already most African countries are moving towards a new international trade order. As more trade power countries are coming up, as more trade deals are being signed, international trade deals are being signed, bilateral agreements are being signed, maybe it's going to be an absolute pleasure to draw from your well of wisdom on what is the need for lawyers when it comes to unlocking value in this area. Ladies and gentlemen, we are merely hosted at the prestigious ULS house under the Radical New Bar. So you cannot, and we cannot begin our webinar or invite any of our panelists to begin speaking before at least we have a member from the Secretariat giving us opening remarks, so that we have that blessing to be able to discuss. And the views that you're going to hear this morning are views that indeed the ULS is very passionate about in building capacity. That is why, for those of us who joined only to get points, you're still going to get points, but you're going to get so much more because you're going to walk away with a wealth of knowledge. It's my pleasure to invite you, Doreen. Doreen is like our caretaker. She takes care of our affairs, all of us as lawyers. So I see many of our members, or even those who are inboxing us for CLE points, they were able to pay. the people who are senior lawyers. I don't see any young lawyer on this panel, but later in October, we are going to be having some elections happening at the annual general meeting, so many young lawyers will be physically there. Doreen, you're welcome, in the interest of time, to take us through your opening remarks.
Thank you so much. Good morning to you all, dear participants here online with us. It's my honor and pleasure to welcome you this morning. Just to thank you so much for joining this training today. It's my great pleasure to welcome you to today's CLE training on international trade, held under the theme International Trade in Times of Crisis, Lessons and Opportunities for Lawyers. This training aims to explore the impact of recent global and regional crises on international trade and frameworks, and to provide legal practitioners with practical insights into crisis-related trade instruments, policy responses, and dispute resolution mechanisms, among other key areas. I'd like to extend my sincere appreciation to our esteemed speakers for graciously accepting our invitation to share the expertise with us today. I encourage all the participants to actively engage in the sessions. You ask questions, share perspectives, and make the most of this opportunity to learn and exchange ideas. Thank you once again, and I wish you fruitful and enriching session today. Thank you. God bless you.
You remember the virtual clapping that we talked about? It will be nice if we can have some virtual hands over. Yes, thank you. This is a very, very good audience. Thank you for those virtual hands of applause to Doreen, who is our Members Affairs and takes care of us. Ladies and gentlemen, without any further ado, it's my pleasure. I want to invite our very first panelists. I see people are introducing themselves in the chat. Nathan Trinomugisha of Paul Tusubira and Company Advocates, you're most welcome. Tenywa Joseph of Messrs. Balidawa Ngobi and Company Advocates. It's a good thing. Sometimes on our lawyer groups, people are looking for who is in this firm. Can someone get me a contact in this firm? So when we come for these online webinars, it's also a privilege that we introduce ourselves. I see quite a number of colleagues who have been in this area of international trade or regional trade online. Wow, it's a pleasure. The numbers are soaring higher and higher. Thank you so much for joining. Many people are used to ULS beginning our webinars on time, so thank you so much for joining. And we intend to be keeping the time as we have promised. We'll continue highlighting the different people we are seeing joining online. Andrew O'Mara from Tumwesije, Louis, and Company Advocates, you're most welcome. All of us are most welcome. We have the numbers, they are soaring, so we believe we have quorum, if that was it, to begin with our webinar this morning. So our first speaker, ladies and gentlemen, is none other than Mr. Emmanuel Sebijo Semanda. Mr. Emmanuel Sebijo Semanda, in this area of practice, has distinguished himself both in consultancies but also being a thought leader. Some of the webinars and panels that we have interacted with Emma, his thoughts have been provoking, both to the public sector and private sector. Emma, this time we are talking to lawyers, we are talking to ourselves, and the point is we want to unlock value in this area. Mr. Semanda is going to be talking to us about 25 years of ESC law, core doctrines, and domestic application. I already have quite a number of lined up questions, but I believe that those questions, as you keep them coming in, Mr. Emmanuel is going to be helping us to dissect and be able to put value to this issue. In about year 2000, Mr. Emmanuel, this ESC community was revived after its collapse in 1977. 25 years down the road, really, what is it that we are seeing as that has been the core doctrine of the revived ESC, which was initially defunct, and what has been the domestic application, so that we understand as lawyers on this issue of community law, the issue of regional trade, the issue of trade law, what is it that we need to be taking away this morning? Over to you, Mr. Semanda. Thank you.
Thank you so much, my good friend and colleague, Leston. Good morning, ladies and gentlemen. My topic today is 25 years of ESC law, core doctrines and application. And along the way, I'll be highlighting the practical implications and opportunities for lawyers. But I can immediately begin by saying that the East African community has 8 partner states now. That is Uganda, Kenya, Tanzania, Rwanda, Burundi, South Sudan, DRC, and Somalia. And together they constitute a population of 300 million people and a combined GDP of $350 billion. Now already that is a very massive opportunity for lawyers to tap into in terms of clientele, stretching from just the local market of Uganda to the East African market of 300 million people. Already you can see that the opportunities for clientele increase, not only individuals or not only natural individuals, but also legal individuals and public bodies and other institutions. Then when you look at $350 billion of GDP, you can imagine the amount of economic activity that is there for us to tap into if we really unlock and take a bit more enthusiastically ESC law. The second point is that ESC law is the most immediate avenue for any lawyer to practice international trade law because it emerges from home, from Uganda, as opposed to, say, AFCFTA law, which emerges from the entire continent or which stretches across the entire continent, so that perhaps an issue might arise from as far as Libya, where we do not have direct access or direct influence to get the matter instructed. And WTO law, which stretches across the entire globe, so that a matter might arise in Australia, where we do not have direct access or direct links to get the instructions. So the pool of lawyers in the East African community, are just sufficient, are adequate for the opportunities that are available. And so ESC law should be taken quite seriously. And this is why I must applaud immediately the Uganda Law Society for arranging this CLE training and also for inviting me. My name is Emmanuel Sevi Jose Manda. I'm the Dean Faculty of Law, International University of East Africa, and I'm the Executive Director at the African Institute of Regional Integration Studies. The summary of my presentation is as follows. I will look first at the sources of ESC law, then we shall delve straight into the doctrines of ESC law, moving on to the application of ESC law, and then we shall make some highlights. So short and simple. First, the sources of ESC law. The primary source of East African community law is the East African Community Treaty itself. The full title of that treaty is the Treaty for the Establishment of the East African Community. It was signed in 1999 on November 30th, and that is why we commemorate the date of November 30th as the anniversary of the new East African Community, but it came into force in July of 2000. Therefore, this year it made 25 years. The ESC Treaty has very many provisions that confer rights and obligations both on individuals and on states. The second source of ESC law are the protocols and annexes to the ESC Treaty. The fundamental protocols, or the primary ones, are the Protocol on the Establishment of the East African Customs Union of 2005, the Protocol on the Establishment of the East African Community Common Market of 2010, and the Protocol on the Establishment of the East African Community Monetary Union. We shall be looking at some of the rights under these protocols, and we shall see how interesting they are for our clients. The other source of ESC law is the Acts of the Community. Acts of the Community are enacted by the East African Legislative Assembly, and they only come into law once they are assented to by the heads of state of each partner state. So you can imagine already domestically, once we have bills of parliament passed, the assent process with just one head of state can be cumbersome. Now, this is one of the challenges with the East African community, because you then have to get this bill from EALA and pass it across all the 8 heads of state to assent to it. They all have their own schedules and their own comments that they might have to make. And the process involves them making comments and advising on amendments, if any, just like in the domestic process. So already we can highlight a challenge that the making of law in the ESC can be quite slow. But already we have made quite a number of laws in the East African community, most significant of which is the East African Community Customs Management Act, which is amended every year, almost regularly, and the EALA Elections Act of 2011. But there are so many other acts of the community that have been enacted successfully, and I advise you to look them up. The final source of law are council regulations, directives, and decisions. These are regulations, directives, and decisions of the Council of Ministers of the East African Community. The Council of Ministers is made up of the Minister of East African Community Affairs of every state, of every partner state of the ESC, the Attorney General of every partner state of the ESC, and any minister that is assigned from any partner state of the ESC, depending on the topic of discussion. And as a functional device, the treaty allows the council to break itself out into what it calls the sectoral councils. Sectoral councils are councils of ministers in a specific sector, say such as finance, where the ministers of finance meet at the sectoral level. All of these councils, whether it's the general council or the sectoral council, can pass directives and regulations that have legally binding effect across the ESC. It's a very important power and a very important legislative mechanism that lawyers should not ignore. An example of regulations and directives passed under this source of law include the East African Community Customs Management Regulations. These are usually passed under the East African Community Customs Management Act. The East African Community Competition Regulations. These are coming in very, very handy and very, very importantly for lawyers in the competition sector, because now the ESC Competition Act has essentially been activated with the establishment of the ESC Competition Commission. We have an example of a council directive, which is the Council Directive 2014/16/ESC on mergers and takeovers. There are so many directives that the council has passed. However, they are not known by lawyers or followed up by lawyers, and sometimes their lawyers' clients miss out on the rights that are conferred upon them, or omit to perform the obligations that are conferred upon them under these regulations and directives. So once again, it's important for lawyers to know and understand that the ESC makes law through council regulations and directives, and it's important for lawyers to keep up to date with those regulations and directives. We're going to see in this presentation how these laws are basically effected domestically. And that takes me directly into the doctrines of ESC law. The doctrines of ESC law. The primary or most important doctrine of ESC law is the doctrine of precedence. This doctrine is that ESC law shall take precedence over conflicting national law on the same topic. So, for example, the East African Community Customs Management Act shall take precedence over any conflicting provision of the domestic tax law of any state, of any partner state of the ESC, including Uganda's Income Tax Act, for example, or Uganda's trade and customs regulations, or statutes. This is set out in Article 8.5 of the ESC Treaty, which says that the partner states undertake to make the necessary legal instruments to confer precedence of community organs, institutions, and laws over similar national ones. The most important case law example for this doctrine is Professor Anyang' Nyong'o and others versus Attorney General of Kenya and others. It's a 2007 case determined by the East African Court of Justice. And the basic issue there was that the ESC Treaty has a provision on the election of EALA members or representatives of the East African Legislative Assembly. However, the Kenyan National Assembly also passed its own regulations for that election process that were in conflict with the ESC Treaty provision, which is in Article 51 of the ESC Treaty, which required that representatives of each partner state to the East African Legislative Assembly will be elected by the members of parliament of the national parliament of that state. In this case, however, Kenya simply sent a list of nominees. There was no election at all in the House. The political parties and the government simply came together and entered a consensus and forwarded a list. The East African Court of Justice stopped the swearing in of the Kenyan representatives following Professor Anyang' Nyong'o's suit against the Attorney General of Kenya and the Secretary General of the East African Community. But I find that these quotations from the court are very instructive. And essentially they are that Kenya's national laws, be it the rules of procedure for electing EALA representatives, cannot override the ESC Treaty requirements. And therefore, the ESC Treaty must be observed in precedence of ESC law, of national law, where there's a conflict. The court had this to say: the dichotomy that this situation poses is as follows. The National Assembly of any democratic sovereign state has the powers of regulating its conduct through rules of procedure by whatever name called. Once made and adopted, they are binding until revoked, amended, or otherwise modified by the National Assembly itself. Ordinarily, what the National Assembly does in accordance with such rules is lawful and valid. However, a state which in exercise of its sovereign power binds itself to an international treaty may end up facing conflicting demands, namely the demand to abide by its treaty obligations and the demand to abide by its own rules that conflict with the former. And this second paragraph is where the court applied the pinch. We think the solution lies in the basic principle at international law, to the effect that a state party to a treaty cannot justify failure to perform its treaty obligation by reason of its internal inhibitions. It cannot be lawful for a state that with others voluntarily enters into a treaty by which rights and obligations are vested, not only on the state parties, but also on their people, to plead that it is unable to perform its obligation because its laws do not permit it to do so. Finally, the court continued that we are constrained to say that when the partner states entered into the treaty, they embarked on the proverbial journey of 1,000 miles, which of necessity starts with one step. To reach the desired destination, they have to ensure that every subsequent step is directed forward towards that destination and not backwards or away from the destination. There are bound to be hurdles on the way. One such hurdle is balancing individual state sovereignty with integration. While the treaty upholds the principle of sovereign equality, it must be acknowledged that by the very nature of the objectives they set out to achieve, each partner state is expected to cede some amount of sovereignty to the community and its organs, albeit in limited areas, to enable them play their role. So we see here that the court is saying that you cannot have the treaty saying one thing, and your national laws, which are attempting to implement that treaty, saying a completely different thing. You must abide by the treaty. Even if your national law is domestically supreme, it must make way for ESC law where there's a conflicting provision. The second and a final example of this doctrine of precedence in ESC law is Samuel Mukira Muhochi and Attorney General of Uganda. It's a 2013 judgment, once again from the East African Court of Justice. And in this case, Samuel Mukira Muhochi, I suppose, was a lawyer from Kenya who had represented certain persons that were accused of the 2010 or was it the 2011 bombings in Uganda. He was one of the lawyers that represented them, I think, in the extradition proceedings in Kenya. And he came to Uganda on a completely different matter. I suppose it was to visit the judiciary and certain officials as part of a delegation from the Kenyan Law Society. But he was immediately detained at Entebbe Airport and deported back to Kenya. Now, he brought a claim against the Attorney General of Uganda before the East African Court of Justice, asserting that his rights under the ESC Treaty had been breached, particularly his freedom of movement as a person under Article 7 of the Protocol on the Establishment of the East African Community, of the East African Common Market, which provides that all citizens of any partner state of the East African Community shall move freely across the entire community and across each other partner state, any other partner state, without discrimination or restriction. So he felt that he had been treated discriminatively because he had been refused permission to enter Uganda. Now, the court agreed with him and held that his rights under the ESC had been breached by Uganda's actions. In particular, it said this: our view is that, like every other country, Uganda's sovereignty is defined by law. Prior to the entry into force of the treaty and subsequently the protocol, Uganda's sovereignty to deny entry to unwanted persons was defined by the Citizenship and Immigration Control Act, Cap 66 as it was, the laws of Uganda. The treaty then came into force. This is my emphasis, but this is what the court said. And just to pause at this moment to highlight that the Attorney General had argued that Uganda has sovereignty over her borders and that Uganda's domestic law, which is the Citizenship and Immigration Control Act, had the ultimate provisions on who enters Uganda's borders and not the East African Community Common Market Protocol. The court disagreed, and it continued. Like in any other partner state, once the treaty and subsequently the protocol were given force of law within Uganda, they became directly enforceable within the country and took precedence over national law that was in conflict with them. Existing legal provisions became qualified and started to be applicable only to the extent that they were consistent with the treaty and the protocol. These include provisions in Uganda's Citizenship and Immigration Control Act. The import of these provisions is that by accepting to be bound by them, with no reservations, that underlining is an emphasis by the court itself. Uganda also accepted that her sovereignty to deny entry to persons who are citizens of the partner states becomes qualified and governed by the same, and therefore could no longer apply domestic legislation in ways that make its effects prevail over those of community law. And the court concluded, sovereignty, therefore, cannot take away the precedence of community law, cannot stand as a defense or justification for non-compliance with treaty obligations, and neither can it act to exempt, impede, or restrain Uganda from ensuring that her actions and laws are in conformity with requirements of the treaty or the protocol. it was a very resounding rebuke of Uganda or of any other partner state that asserts its sovereignty or its internal legislation as a defense to breaches of ESC law. These two cases, Professor Nyang' Nyong'o and Samuel Mukera Muhochi, present two important elements that every lawyer should have at the back of their mind. One, a state cannot rely on its internal or domestic legislation to breach clear and unambiguous East African Community Treaty law. Second, a state cannot rely on its sovereignty to justify a breach of ESC law, because, as the theme of the two judgments by the court goes, if you are sovereign and if you want your sovereignty so badly, do not enter into binding international agreements with others, because if you do so, then you allow yourself a limitation to your own sovereignty, because in essence you are pooling your sovereignty with other states into in that agreement, and you have to ensure that that agreement is fulfilled, even when that requires sometimes waiving certain aspects of your sovereignty. The second doctrine in ESC law is the doctrine of direct effect, and this is the final doctrine. That doctrine is that rights and obligations arise under ESC law, and that they can be invoked directly by individuals before national courts. So they arise under ESC law, they are directly implementable in the domestic states without further translation into domestic acts or regulations. And individuals can rely directly upon them before their national courts. Before I get into the legal framework for this doctrine, let me highlight the core ESC rights that lawyers should be advising their clients upon. First is the free movement of goods, or the right to free movement of goods. This is under Article 6 of the East African Community Customs Market, Common Market Protocol, and the East African Community Customs Union Protocol. That is what I'm abbreviating as the CMP, that's the Common Market Protocol, and the CUP being the Customs Union Protocol. Those protocols provide that no tax or duty or charge having an equivalent effect, for example, a so-called environmental levy or a so-called bond fee, will be charged upon any good that is coming from one East African state and crossing into another East African state. All customs duties, all taxes, provided they are border taxes, and all levies or any charges having equivalent effect are prohibited. And goods coming from all partner states must be treated equally. That is, they must not be discriminated against. For example, you must not discriminate against soya beans coming from Tanzania as opposed to those coming from, say, Rwanda, and vice versa. Of course, in saying this, there are derogations or exceptions to these rights, and these entail an exception on the basis of public policy, public health, and public security. We have seen many instances where countries or partner states have essentially presented a barrier or blocked the free movement of goods under the pretext of those justifications of public policy, public health, and public security. In many of those instances, it's been an outright abuse of those derogations, and so there's a lot of work for lawyers to do in really shaping those exceptions or justifications through litigation and bringing states to book for abusing those derogations or exceptions. The second core right in the ESC is the free movement of persons. This is under Article 7 of the ESC CMP. And this is essentially that any citizen of any partner state shall move and be allowed into any of the other partner states without discrimination or restriction. And when in those partner states shall be allowed to move across the entire partner state, just like the citizens of that partner state, without discrimination or restriction. The other right, the third one, is the free movement of workers. This is in Article 10 of the East African Community Common Market Protocol. And briefly, this is that any employed person who is a resident or citizen of any partner state of the ESC. So it doesn't matter if I'm a Ugandan employed in Kenya or if I'm a Ugandan employed in Uganda. They have the right to seek, gain, and take up employment in any other partner state of the ESC without discrimination and without restriction. So, for example, a Ugandan who has been appointed as managing director of a technology company in Kenya should not be denied a work permit in Kenya, whereas a Tanzanian appointed in a similar position in a similar entity is given a work permit. That will be outright discrimination. But also the processes and procedures and fees involved with gaining a work permit should not be restrictive. The free movement of workers has other secondary rights, including the freedom to move with family. This is family rights. That is, once I'm a worker taking up employment in another state, I have the right to come to that state with my spouse, my children, and my dependents. And those two should not face any discrimination or restriction. The fourth core right of the ESC is the right of establishment. This is set out in Article 13 of the ESC CMP, and this right is broken down into two. First is the right of self-employed persons to establish themselves in other partner states. So, for example, I might be a Ugandan musician who is self-employed in Uganda and going about my concerts and music. I have a right to go to Tanzania and begin my self-employment there as well, and perform at concerts and do my music and take up radio interviews and marketing promotions without discrimination, without being treated differently from a Tanzanian musician or from a Kenyan musician in Tanzania. The second aspect of the right of establishment is the right of companies to establish themselves. And this right also takes up two separate approaches. The first is that a company can establish its primary entity in any partner state of the ESC. That is, a company can move its headquarters or its country of registration from Uganda, say, to Burundi without discrimination. And secondly, the right to set up secondary establishments. That is, a company may set up subsidiaries or distribution centers, etc., in another partner state without discrimination. What we have seen with most of our national laws is that they have national requirements for establishment. For example, some partner states require that to establish a company in their state, you must have a citizen of that state having 51% of the owning the majority of the company before that company is recognized or can be registered. And the same applies also with subsidiaries. Now, these are discriminatory and they're restrictive practices which are prohibited by the Common Market Protocol, because the essence of a common market is free movement, is a borderless community. And borders, by borders we mean removing both the physical borders or the political and geographic borders, and also the legal or regulatory borders. It's supposed to be a common market, a free market across the community where goods, persons, workers, establishments, companies, self-employed people are moving swiftly and without discrimination. This will spur the economic growth through, obviously, what we have, or what we would call the economic integration. Moving on to the other rights is the free movement of services, which is very core to us lawyers. That is that a service provider is allowed to move to any other partner state of the ESC to provide their services. And secondly, their service is allowed to move freely and without discrimination to any of those other partner states. That is, for example, a lawyer in Uganda is allowed, under the Common Market Protocol, to provide legal advice to a client in the DRC. That is, his service should be able to move freely to the DRC. He's also allowed to move to the DRC and represent or advise his client there. Once again, we have seen very many restrictions, domestic restrictions, not only for lawyers through the regulatory bodies of the lawyers, but also of the other professions and also other institutions or entities like banks. There's a lot of restriction to movement of services, to movement of banking services, for example, whereas the treaty and the Common Market Protocol require that, for example, a bank that is established in Kenya should be able and should be allowed to provide its service freely to the entire East African community without seeking re-regulation. Now, these are very sensitive issues, especially also, from the regulatory perspective. But this is what the law requires. So it is for lawyers to know the law and forge a way of either implementing it or finding a way to apply it through their own legal devices. Second last is the free movement of capital, which is that money, or especially resources meant for investment or for any economic activity, should be able to move freely across the community without barriers, without restrictions, and without discrimination. So I should be able to send money from MTN Mobile Money Uganda to MTN Mobile Money Rwanda without really any limitations or without being charged discriminatively. So the charges that apply to a Rwandan in Rwanda sending money to a Rwandan MTN Mobile Money number in Rwanda should be the same charges that apply to a Ugandan in Uganda sending mobile money to a Rwandan number in Rwanda on MTN Mobile Money. This is free movement of capital. The way that we move our money from banks, from banks in Uganda to banks in Tanzania, the way that clients move their monies from banks in Uganda to banks in Kenya, for example, to invest or to take up other opportunities there or to invest in the capital markets, is essentially should be a barrierless and non-discriminatory procedure. But we find very many barriers and prohibitions to this type of movement. And this presents, one, an opportunity for lawyers, but also secondly, an opportunity for your clients to explore these opportunities. Sometimes it may need pressing them through the courts, as we shall see later with the doctrine of direct effect, but it can be a very worthy cause when you look at it in the context of very many years later. And finally, we have human rights, good governance, and democracy rights in the ESC. These are under Article 6D and 7.2 of the ESC Treaty. Interestingly enough, these human rights, good governance, and democracy rights have been the ones that are most implemented or most advocated for by lawyers. This is not necessarily a bad thing, and it is highly encouraged. However, we should also not lose focus on the economic rights that we've highlighted. And it would be good to see lawyers and law firms taking up matters and advising their clients on the economic rights that equally arise from the same laws and the same instruments as these human rights, good governance, and democracy rights. So moving then on to the doctrine of direct effect, or coming to illustrate it better. As I said earlier, it is that directly enforceable. Is that rights are directly enforceable in domestic legal regimes and or before national courts. Okay, rights and obligations under the ESC Treaty and the protocols thereunder are directly enforceable in domestic legal regimes and or before national courts. And this is once again set out in Article 8.5, which we saw earlier, that ESC law should be given application and precedence in the ESC partner states. In particular, Uganda has accepted this and has enforced ESC law and enforced the ESC Treaty and its protocols through the East African Community Act, CAP 187. It was formerly the East African Community Act of 2002. This East African Community Act, I encourage every lawyer to have it on their desktops. It's very important. It says in the preamble that whereas it is expedient to give the force of law to the treaty, that is the ESC Treaty, in Uganda, now therefore be it enacted by Parliament as follows. And Section 3.1 says, the treaty as set out in the schedule to this act shall have the force of law in Uganda. So the East African Community Act, CAP 187 of Uganda, Section 3.1, is very clear that the ESC Treaty, and therefore also the ESC Treaty and its protocols, and all council regulations and directives enacted under that treaty, have the force of law in Uganda. There is no need for any other act to domesticate the free movement of goods, the free movement of workers, the free movement of capital. We have basically taken the treaty and these protocols and said all of them, the way they are, and any subsequent amendments, as we shall see in subsection 2, they will have the force of law in Uganda. And of course, Uganda being a dualist state from the perspective of international law, which is that for an external law to be applicable in Uganda, it has to be given force of law by Parliament, because the National Parliament of Uganda is sovereign and is the only one under the Ugandan Constitution that is mandated to enact law for Uganda. Therefore, it means that any law that the executive may sign binding Uganda externally must be put before Parliament for it to be enacted. For it to be enacted by Parliament and given the force of law. So Section 3.2 then says, without prejudice to the general effect of subsection 1 of this section, all rights, powers, liabilities, obligations, and restrictions from time to time created or arising by or under the treaty, and all remedies and procedures from time to time provided for by or under the treaty shall be recognized and available in the law and be enforced and allowed in Uganda. So this is once again creating the doctrine of direct effect and applying it to Uganda. And this doctrine has been discussed in the East African Court of Justice, in that case of East African Law Society and the Secretary General of the ESC, where the court essentially held that it would be absurd if national courts cannot be called upon by individuals to apply ESC law in the domestic regime. So the court here was saying that if any individual has any quarrel about a breach of ESC law, that individual can take that matter to the national court. It's not a matter of always going to the East African Court of Justice. The individual can go to the national court, and the national court can apply the ESC law directly in that case. So I've set out, because this presentation may be shared, I won't go into this case law, but I've set out a number of case law examples where the courts of Uganda have directly applied ESC law in national legal disputes. The third topic is application of ESC law, and this is essentially the final topic. I'll cover it in 2 minutes. ESC law is applied through 3 or 4 devices. The first one is preliminary rulings, and this is in Article 34. And it essentially says that when an issue or a question of ESC law arises before a domestic court, that court should refer that case to the East African Court of Justice to make a preliminary ruling on it. And once the court makes a preliminary ruling on it, the domestic court must apply that ruling in that case to that matter. So it works in much the same way as constitutional references in domestic legal regimes. So when we go to invoke ESC law before national courts, and there's a question that arises of ESC law, you can always encourage the court to refer that question to the ESCJ to make a determination on it. However, as the court set out, the East African Court of Justice set out in the case of Attorney General of Uganda versus Tomcha Hurenda, not every question should be referred to the ESCJ. If the question is about, if the answer to the question is clear, or if the answer to the question is obvious, for example, if the question is cotton, an agricultural product, the court should be able to answer that question. The domestic court should answer that question without referring the question to the ESCJ. And also, if the provision is absolutely clear and there's no need for interpretation, or if the ESCJ has previously pronounced itself on that provision, the domestic court does not need to refer it for a reference. The second mode of applying ESC law is through individual references. This is Article 31 of the ESC Treaty. Individuals can challenge partner states and the community organs or institutions directly before the East African Court of Justice with a time limitation of 2 months. The third one is partner states references. Partner states references. And this is that partner state, and this goes out to officers in the Attorney General's office, because partner states can challenge other partner states and other organs before the East African Court of Justice. This is under Article 28. The next one is Secretary General's references. Secretary General's references. These ones are regulated by Article 29 of the ESC Treaty. And essentially, this one also goes out to lawyers, is that individuals can move the Secretary General to challenge any of the partner states regarding a breach of the East African Community Treaty. So any individual, and therefore a lawyer, can write to the Secretary General, bringing to their attention a breach by a partner state of the East African Community of a breach of ESC law, and asking them to lodge a claim in the ESCJ to bring that partner state to book. Employment disputes involving the community, that's the East African Community, and its employees are within the exclusive jurisdiction of the East African Community Court of Justice. They cannot be brought before national courts. Very interestingly also, the ESCJ has arbitration jurisdiction. And most interestingly is that it does not charge fees for arbitration. You simply pay the normal filing fees, but the arbitrators do not charge fees. And so private parties can bring their disputes for arbitration before the ESCJ, and so can the community do so. The final one is advisory opinions. The East African Court of Justice can deliver advisory opinions on any question of East African Community law, only that the local standby before that court for advisory opinions is only the summit, the council, or any partner state. So once again, for officers working for the East African Community's council to the community, or in the Attorney's General office or offices of the partner states, you can request on behalf of those states, you can request the ESCJ to deliver an advisory opinion on certain aspects of the community on which there are some ambiguities. And so far, the ESCJ has delivered 2 advisory opinions. So in conclusion, my highlights and parting shots are: 1, the doctrines of ESC law are the doctrine of precedence and the doctrine of direct effect. A core aspect of enforcing ESC law is through going to the national courts of law of the partner states and requesting them to make preliminary references of any question of ESC law that arises in those courts to the ESCJ. But where the question is obvious or clear or has been answered before, to go ahead and determine the question. You should also consider making individual references before the East African Court of Justice, but once again consider making them not only for breaches, of human rights, but also of the economic rights. I think I've seen a claim by Mr. Kalali recently challenging Tanzania's prohibition of small-scale traders, including Ugandans. And so my parting shot would be that lawyers should advise their clients on the community rights and actively invoke the doctrine of direct effect before national courts, as opposed to always filing cases at the East African Court of Justice, because one, it is significantly backlogged, and two, it takes a very long time to deliver its rulings and judgments, because it is an ad hoc court at the moment and not yet permanent. So an avenue of justice is national courts. Thank you.
Wow, thank you so much, Mr. Emmanuel Sevijo. Like we said earlier, there is a virtual hand clap you can do. You can just try it out. When you go to React, you will find that you're able to raise your hand under the icon of React, but also after a presenter has made a presentation. Yes, I see hand claps coming in. It means that people are following your presentation. But I have some questions that have come in, which I want, with the permission of the other panelists, that you be able to attend to them a bit later as we are doing the plenary. But when you raise the issue of sovereignty versus integration, it seems we persuade each other to enter into these agreements only to call on, we are a sovereign state, we are not bound by what other states are saying. So the question, which is a difficult one, and thankfully I'm not the one answering it, is that how can partner states practically balance national sovereignty with the doctrine of precedence of EAC law? We have seen Supreme Court cases of partner states being subjected to the ESCJ, the East African Court of Justice, and there is usually a rift there of domestic judges feeling at the ESCJ justices overstepping, yet even the people who sit at the ESCJ are justices appointed from domestic courts. The other question, which will still come back to the plenary, I'm going to write this down and share them, is that given that the treaty and the protocols are said to be directly enforceable, what strategies can lawyers use to persuade national courts to consistently apply ESC law in practice? Because you'll mention an ESC instrument and a judge may look at you a certain way. Say, were you not taught sources of law? Don't you know Section 14 of our Judicature Act? Thankfully, we have justices such as Justice Henrietta Wolayo is on call with us, ladies and gentlemen. I strongly believe she didn't join because of CLE points, like one of the participants was asking, why are you delaying our CLE points? Yes, people like Dr. Henry Honoria is also on call. I earlier on had highlighted his worship, Mr. Frank Nigel Thembi. So we have quite a number of people following this discussion, but we'll come back to you just at the plenary. At this point, I want to add a bit of spice to this conversation by inviting my brother who has interesting views. Mr. Ivan Ojakol is a partner at Matrix Advocates and leads the international trade practice there. He has undertaken a number of postgraduate qualifications in international trade law and policy, trade finance under TRAPCA, reading and interpreting the African Continental Free Trade Area Agreement under TRALAC. He has experience advising clients on aspects of the ESC, on COMESA, and the African Continental Free Trade Area, including representing clients at the East African Court of Justice. He is not just passionate practicing this, but he has also taught international trade at the university. Now, Mr. Ivan Ojakol, the issue about this African Continental Free Trade Area, we want you to add to the discussion what is in need for lawyers, because already we have the ESC we are grappling with. We have those challenges. Now we are saying we are going continental. What is in need for us when it comes to the African Continental Free Trade Area? Please take it away, and then later we have a surprise. The final panelist is going to come as a surprise after Ivan's presentation.
Thank you.
Let us welcome Mr. Ojakol by giving him a virtual Hand of applause, ladies and gentlemen. You're most welcome.
Thank you very much. For starters, it's no mean feat following my former boss. People may not know it. Mr. Sevijo Semande is my former boss. So really, the work is cut out for me, and I have a Herculean task to follow through with, not disappointing him. Firstly, a brief answer to your question. AFCFTA is everything for lawyers as far as legal practice and as far as creating opportunities for lawyers is concerned. What is the AFCFTA? Others say after, like my colleague, the after, oh, I don't know what other acronyms are there. Largely, and thankfully, my conversation is a build-up from Mr. Sebijo's discussion. Largely, there's something called Agenda 2063, which the AU, African Union, came up with in order to make Africa a powerhouse. Literally a master plan, a blueprint for Africa's development. They have a number of flagship programs, top of which is the AFCFTA, but there are others. And people usually ask this question, that how is the AFCFTA going to work in a continent that has very poor infrastructure, very bad roads, very bad amenities? AU is saying we have plans for all of this. There are a number of programs. There's one called PIDA, Program for Infrastructure Development in Africa. There's one called Accelerated Industrial Development for Africa. There is an interesting one which has been shelved for a very long time and was actually presented to the heads of state in Kigali in 2018, but for some reason they ignored it for reasons best known to them. So before the AFCFTA, there was another protocol which had been developed on the free movement of persons and right of establishment, a right of residence, but it has not gotten the required number of ratifications to date, and unfortunately still on the back burner. I don't know why Africans, we just welcome each other for a group of people that claims to be very hospitable and very loving. I don't know why anyone who travels regularly in this continent knows the visa nightmares that come, especially crossing over certain areas or certain countries. So there are a number of them, and you can go to the African Union website, and there are a number of them. There's even one on a single African air transport market. I mean, what explains the fact that a ticket to Kenya is more expensive than one to Johannesburg? I mean, things like those. Are we going to really have it African trade when we cannot? So those initiatives are all there and are in the pipeline alongside the AFCFTA. So the AFCFTA is largely a rules-based trade agreement that establishes a free trade area targeted at liberalizing trade in goods through tariff concessions and preferential rules of origin, liberalizing trade in services in a reciprocal manner. Basically, an argument calling for improved trade governance, trade facilitation, and better border management. It is contained in different components. One, there's a mother agreement, which comes along with protocols which have been completed. Only 3 protocols have been ratified. There are a couple of others which have been adopted but not yet ratified, like the Protocol on Investment, Protocol on Competition, Intellectual Property Rights, Digital Trade. There's one which is being discussed right now, a protocol on women and youth, and a couple of others in the pipeline. I have, for example, called for one on sports, because I think the global industry of sports is too big for Africa not to tap in, so we need perhaps something like that. There are a couple of others which have been discussed, the discussions on climate change, etc. So, however, of course, there are discussions around Africa, despite all of these trade arrangements that have been developed over the years, not tapping into the global trade economy or benefiting from a multilateral trading system under the World Trade Organization, or even before the World Trade Organization, under GATT. Africa accounts for 17% of our global population, but only contributes 2.5% of global exports. Only has about 2 to 3% of global trade. In Africa alone, the fluctuations are usually between 12 to about 17% in terms of intra-African trade. So we trade more with other people outside the continent than with among ourselves. And also perhaps no wonder we don't even like welcoming each other without unnecessary impediments to our countries. So the agreement was signed in 2018, came into force in 2019 after achieving the required number of ratifications. Trade in goods kicked off officially on January 1st, 2021. Only Eritrea, out of our 55 recognized African countries, has not signed it to date. A lot of the so-called inter-African trade is dominated by a country called South Africa, which accounts for 37% of intra-African trade and intra-African imports. So it is quite dire. And it is against that background that Africa has decided that, you know what, the only way we're going to have a chance in times like these, when even generalized system of preferences like AGOA, all but arms, and among others, have not really benefited us. And AGOA, you know, is supposed to actually end this month. But again, in terms of numbers, has not really benefited Africa. So we have to create a solution for ourselves internally. Basically, the AfCFTA is Africa saying it is our time. So basically, the AfCFTA is Africa saying it is our time and our time is now. But it's also important to go through a brief historical background of where we have come as Africans regarding the AfCFTA and just our history regarding trade. Africa, it's not the first time that Africa is trying to integrate. And perhaps this is one of the reasons why there are some naysayers or even pessimists regarding the AfCFTA or whatever integration initiatives usually are mooted by our heads of state and different governing international trade governing bodies in Africa. Africa started its integration efforts, if you recall from your history, during the colonial times, because it was seen as a way of, you know, any colonialism. African states formed alliances, among others, came together and supported each other, whether through arms or training, etc. If you remember what Gamal Abdel Nasser and a couple of others did for a couple of African countries as far as their decolonization efforts are concerned. So that's the 1950s, 1960s. Africa gets independence. Regional blocks like SADC are created to help with ending white minority rule in South and Southern Africa. The OAU around that time is formed. We should have a discussion about the OAU, and because it is perhaps the most foundational, its creation is perhaps the most foundational aspect as far as what we have as the AfCFTA now. So OAU, a gentleman called Kwame Nkrumah mooted it, was among the first mooters of that body. And philosophically for him, he believed Africa should have a United States of Africa. Of course, that was without a doubt going to come under challenge because one, these African countries, pursuant to the Berlin Conference of 1884, many of our leaders were comfortable in their small conclaves created by colonialists and were like, no, we do not want that. You, for selfish reasons, want to be the president of Africa. We have just got an independence, it is our turn to eat. Let us also first enjoy. So there were debates back and forth. A couple of groups led by Nyerere, Monrovia group, was saying, no, okay, we agree with you, Africa needs to integrate, but however, the United States of Africa is too fast. Can we take it gradually? And first, integrate slowly, maybe through regional blocks, etc., then eventually we can arrive at a United States of Africa or a political federation. So those debates went on and on, but eventually the likes of the Monrovia group, of course supported by the colonialists who still had interest in Africa, prevailed, and the OAU was founded. Then came the Lagos Plan and Abuja Treaty. Lagos Plan was the predecessor to Abuja Treaty, and these ones talked about something called African Economic Community. African Economic Community is actually still in the offing, and like I've mentioned, do not look at the AfCFTA in isolation. There are a number of integration initiatives around it that are happening and are still going on that you should also look at when you analyze the AfCFTA. So, of course, again, Abuja Treaty, African Economic Community, in line with Nyerere and the Monrovia group's discussion on let's go gradually, said, okay, let's form regional economic blocks. Hence, the current 8 regional economic blocks. The East Africa Community, SADC, there's one in the Maghreb region, there's ECOWAS, there's IGAD, COMESA, etc. And they all, many of them are not, by the way, aimed at economic integration. They have other interests. Others are for political interests. Others are for, not all of them are really economic regional blocks. And just before the AFCFTA, there was something which was actually really happening in the region, and personally I thought it was what was going to be the regional economic bloc called the Tripartite Free Trade Area, where we had COMESA, SADC, and the EAC coming together and saying, let's enhance our trade by coming together. Thankfully, around that time is when the AFCFTA also properly got into motion and properly took root and eventually came to life. But that was important because it helped in accelerating, and that is why people were really shocked by how fast African countries or governments signed up to the AFCFTA because of things like this. So the negotiators were able to use documents and other things that had been agreed here to fast track the AFCFTA as far as documentation is concerned, etc. The Tripartite Free Trade Area actually came into force last year, and it's also something you should also pay attention to. But all of these are mechanisms towards the AFCFTA. Now, that discussion is very important because it ties into the language of the AFCFTA, the philosophical underpinnings of the AFCFTA, and why Africa has developed that kind of argument. Many naysayers say that it cannot work because, one, if you critically look at it, you'll be like, okay, are these guys really serious because of certain language, certain things which have been criticized by international trade people, scholars, etc., and are being brought back into the argument. Remember, here is a hugely divided continent by, of course, a legacy of colonialism, us being comfortable with our small borders, but also things like Francophone, Lusophone, Anglophone, again created by colonialists, where people want to remain in their small conclaves. So the negotiators have that background of, okay, Africa has tried to do these things in the past, but they have failed. Remember, bodies like the EAC even collapsed at some point. In West Africa, the original REC also collapsed. So they are aware of all the politics, this history, these cultural differences, and therefore come up with this agreement. Interestingly, the AFCFTA is headquartered in Ghana, but from the language of this agreement, perhaps it should have been headquartered in Arusha or in Dar es Salaam, because it seems Nyerere's language took the day, and his progressive approach and flexible approach towards integration. So you're going to realize when I'm going through the mother agreement that there are certain flexibilities, certain bending over backwards regarding the agreement. And that is why some people think it cannot work. Also because largely you're dealing with LDCs, people who have failed to tap into the global economy, who have struggled to tap into the multilateral trading system. AGOA has been here. Many of them do not have any serious numbers to show for it. So let's go through the argument and we see how some of those philosophical things are contained. As a disclaimer, I will not go through the whole argument, but I will pick out the main aspects of it, which I think are important for us as lawyers. And also, I will not go through all the protocols. I'll go through the 3 ratified protocols, then the others I'll, in a cursory way, go through them, and hopefully maybe in the Q&A we can perhaps have maybe a broader discussion. So there's a mother argument. So the objectives, again, are around trade liberalization, reduction in tariffs, creating market access for Africans to increase that intra-African trade, which for some reason is that low, the lowest in the world. We have failed to trade with the Western world because, one, perhaps we don't have industries to produce finished goods. We are dealing in raw materials which come at a low price. We are the most arable land in the world, but import more food, import the most food into our continent. So that shows you how much the multilateral trading system has been stepped against us. And it was time for us to stand up and say, let's come up with something our own that is bespoke and fits our circumstances. So general objectives, Article 3 of the agreement. Article 4 goes into specific objectives. Again, language is very important. State parties shall progressively, not saying eliminate, no, progressively eliminate tariff and non-tariff barriers to trading goods. And shall see there's even a timeline for that. Progressively liberate, the word is there again. Cooperate, not saying shall have investment, no. Cooperate, because we are LDCs and many of these things are a work in progress as far as we are concerned. Establish a settlement of disputes mechanism, and that is important because this one properly ties up the agreement, among others. The principles are very, very important, and again, tie into that historical background. And if you go into the preamble also, you'll see these things. Driven by member states. Interestingly, there is a distinction between member states and state parties in the agreement. State parties are the ones that have ratified. Member states are all the ones that signed onto the agreement, except Eritrea. RECs are its building blocks, and this is why I say it was important for this discussion to be after Mr. Sevijo's discussion, because a region like East Africa is way ahead as far as its integration efforts is concerned, and is moving towards a political federation if all goes well. So it recognizes that, hey, we're not just going to come and ride roughshod over these guys and say, now take our position. No, we're going to build on what is already in existence. Explains why things like the TFTA, the Commerce as a Visual, etc. This one is a very controversial one. Variable geometry. Recognizing all of these things, and some people have criticized and said, why do you have something like variable geometry if you're serious about integration? I think there's even an advisory opinion from the ESC that variable geometry is something that should be recognized as part of the integration efforts of a community. Variable geometry is basically saying, okay, let me put it as casually as much as possible. You can integrate at your own pace. We are allowing you some flexibilities. You can, and I'm sorry to point out this country, no wonder their leader was the one pushing for a gradual integration effort. Tanzania is very good at this. They integrate at their own pace, and people just wonder if they are serious about it. So that is allowed. Because, again, recognition of bringing countries together at different levels of development. There's no way Kenya and South Sudan can be at the same level of integration, no. So you must recognize these things. Flexibility and special and differential treatment. Again, special and differential treatment. That certain countries, because of where they are, can be allowed to integrate slowly. However, my criticism here is perhaps they have not properly put a timeline. There's a trade agreement called the Trade Facilitation Agreement, which is under the WTO. It has a timeline for when countries should ensure that their borders are properly in place or their custom systems are in place. So special and differential treatment for those who are at a certain level. You can be allowed to move slowly. Transparency and disclosure of information is also very important. And also, this again ties into my discussion. If you think that you cannot implement certain obligations under the treaty, communicate and say, for us, no, this one we shall not be able to, because we believe this industry is important to us, or there is this law that might conflict. Preservation of the acquis. Acquis again ties into RECs as building blocks because it recognizes that the rights and obligations policies of governing bodies that are already in place and must be recognized. National treatment that do not treat goods that have come under a preferential scheme into your country less favorably. Reciprocate a preferential scheme. Consensus decision making, among others. Consensus, everything is done by consensus. Let me quickly run into a very controversial question that usually comes up. Then, how do these two coexist with these RECs? Of course, the principles I've told you, variable geometry, recognize they are key, which is something that came from the European Union. But also, it is alive to the fact that the RECs are building blocks, but also under 19, where there is an inconsistency between an obligation under a REC and the AFCFTA, the AFCFTA prevails to the extent of the inconsistency. However, as provided under this agreement. So meaning, still, remember the argument is saying variable geometry, respect of RECs are key. So still, there'll be a default to that. Even where the AFCFTA prevails, the AFCFTA will have to respect that there are certain principles that govern it, and majorly respecting how the RECs have moved. But again, 19.1 is cured when it says that notwithstanding what is under the argument, where state parties have recognized high levels of economic integration, such high levels of economic integration shall be maintained. Again, if you go into the Protocol of Goods and Services, Protocol on Trading Services, it has similar provisions on that, recognizing the development or the levels of integration achieved under those regs. The Protocol on Trading Goods has similar provisions on special and differential treatment. H2 of the Protocol in Trading Goods also has a similar provision. Protocol on Trading Services has a similar provision on special and differential treatment. Article 15 of the agreement has a waiver of obligations. There can even be a waiver of obligations. Where a country says we cannot implement to this level. We are hard up. Please, this one may be too tough for us. So you can see the agreement is as Africanized and bespoke as much as possible to allow the whole continent under its circumstances to develop at the same level. There's an institutional framework of the Assembly, which is the heads of state, the Council of Ministers, usually the Ministers of Trade, among others. And these are the ones that make the rules. The Committee of Senior Trade Officials that are responsible for governance of the agreement alongside the Secretariat. Quickly, through a Protocol of Trading Goods, it maintains the same principles that have been there in the GATT and the WTO, MFN, Most Favored Nation. What does that mean? That means that you cannot, if you have extended a preferential scheme or an advantage to a third party or another country, please ensure that you extend the same to the other one, especially where you are under a preferential trade scheme like the AFCFTA. So basically, it means when it comes to those goods, please extend the same preferential arrangements. Where possible, you actually, before you even enter with a third party, say for example, Uganda and Kenya privately want to enter into a deeper integration agreement. They must first ensure Tanzania, Rwanda have a look, and the other East African countries have a look at that and see if they agree. So that is what MFN is. It is ensuring the reciprocal basis, advantages, and spread throughout. National treatment, again, goods across the border, do not discriminate against them. Elimination of non-tariff barriers, technical barriers to trade. Non-tariff barriers, things like a president just wakes up and says, close that border. Those guys are over-exporting to our country. Technical barriers, over-requirements on, say, branding, etc. Rules of origin are very important when it comes to trading goods and are perhaps some of the most controversial. It is rules of origin that determine if you are going to benefit under a preferential trade agreement. So basically, they will qualify whether indeed that good should come into under that scheme. If there are reduced tariffs, whether that good should be able to come. So countries agree on that. They'll say, for these goods, we are removing duties entirely. For this one, we are maintaining this amount of duties. For this one, we are not removing anything. Tariff lines to be liberalized up to 90% over 10 years. For LDCs, 5 years. As per the current discussion, it seems they've actually gone up to 92.4% with just a pending few of them. For 3%, countries are like, some goods here, these ones are our major goods, we shall not reduce even. So 3%, those ones. Trade facilitation arrangements, among others. The exceptions, like national security, where you can be allowed matters concerning health, where you can be allowed to derogate from these obligations. Trade remedies is a very important one because there are mechanisms through which countries can be able to go against or block certain goods. For example, anti-dumping duties, countervailing duties, safeguards, among others. The agreements, all of them, trading services, trading goods, provide for technical assistance. So this already is an opportunity for a lawyer to work together with Secretariat in providing technical assistance, and this is one of the opportunities for technical assistance by building capacity of SMEs, lawyers, among others. Protocol trading services, again, quickly to go through it, retains the same modes of supply, the 4 modes of supply: consumption abroad, commercial presence, what's the other one? The third one, where you can set up a company in another country where a consultant under 4 can go and do business in another country. So it has maintained that. However, the right to regulate remains when it comes to services that are regulatory intensive. Country will say on our telecommunications sector, for us, maybe because of security reasons, we don't allow many players in the market. But of course, that must be done reasonably and objectively. mutual recognition of qualifications like lawyers, for example, to allow you to be able to practice in Nigeria. This is also being recognized there under. However, there's no annex. These protocols all have annexes that go deeper in the substantive provisions. I will not go through them because of time. Subsidies are allowed. Subsidies is a very controversial subject, for example, where a government supports through technical support a particular industry in order to enable it to compete elsewhere. They usually tackled through countervailing, among others, but this agreement seems to allow that. Again, the agreement is bespoke to Africa and recognizes our disadvantages in the international trade space. How you do this? By providing a schedule of specific commitments and saying for us on this sector, in our telecom sector, we shall not allow. In this sector, we shall open up. Same thing with trade in goods. You have a schedule of tariff concessions. On this one, we shall allow. This one, we shall not allow. There's a protocol on dispute settlement which cuts across all the protocols and is important. There cannot be a trade agreement without a proper dispute settlement mechanism. Provides for a governing body called the Dispute Settlement Board. Dispute Settlement Board. Okay, let me finish the protocol on dispute settlement because of time. Establish a dispute protocol. It is state party run as opposed to what Mr. Sabji talked about under the ESCJ, which allows private parties to bring an action. Here, only state parties can take on themselves. People have criticized it and said, copy and paste from the WTO, maybe not, but that is how it is. So, so how is it? Let me quickly run to how a dispute starts. So a panel is established to assist in a dispute. Then if you're not satisfied with what the panel says, you go to the appellate body. You initiate it by a complaining party, first attempting to resolve the dispute amicably through conciliation, mediation, good offices. If that does not work, you can also request the head of secretariat to help with that process. If that does not work, you notify the DSB, requesting for a composition of a panel. The DSB does that. The panel makes a report. The report, it's very interesting, by the way, and this shows you how there's a good faith and a sort of conciliatory approach. Even when the panel makes a report, there is a, let me just quickly, there is an interim mechanism of that report being considered. And where the parties still do not agree, then you can escalate it further. So the reports can be enforced from either the panel or the appellate body. Beyond that, if you're not happy, you can, as an alternative, seek for arbitration, of course, by agreeing to it, following the normal principles of arbitration, among others. There are other protocols on IP competition, investment, digital trade, women and youth. Article 23 allows for the creation of more and more protocols. Opportunities for lawyers get skilled up. The DSB is not going to take lawyers who are not skilled in international trade. It is properly stipulated in the agreement. So get skilled up, look for more education, international trade or international law, and look for those opportunities. Advise SMEs, negotiations. We have always first criticism that our negotiators don't do a good job. Among others, disputes, of course, when the DSB is fully functional, there'll be opportunities for you to represent state parties. Of course, that comes with making sure you're in the good books of the Attorney General so that he can appoint you as counsel. I'll stop here and hand over to Mabel or Laston.
Yes, let us have those virtual hands, the virtual hand of applause to Ivan. Ivan, when you speak after your boss, it's also a promotion. It's also a promotion when even Jesus had John the Baptist go before him. And when Jesus came, he just did quickly, in a very short time, quick ministry, and he left. So thank you. Previously from Emmanuel Sevijo, some tough questions that have come in. We have deferred them to the plenary, for the plenary, which is going to come after our final presenter. We also had a very good presentation from Ivan. Ivan, the topic you're discussing literally needs a full semester. So first, making people to understand what is this animal called AFCFTA, then going to what is the need for lawyers, but you've done quite a commendable job. You know, when we hear disputes, that's when we try to wake up, but there is a lot of work even before disputes arise, and this is the surprise that the Radical Nuba had for us. It was intended that the only lady on the panel feels to be protected by having her come when the temperature is well set. I see our participants are continuing to increase. We are right on time. Our program is running very, very accurately on our time. We are keeping our time very well. So by 1, we will really be done. We only have 2 things remaining. We are going to have the third speaker, and after the third speaker, we'll go to the plenary. We have intended to give it a bit more time so that the people who have been able to put their questions to the panelists, they are able to speak to them, but also those that want to contribute to the conversation in the plenary, you raise your hand. I hope you know how to find the hand to raise it so that the people in the technical team will give you speaking rights. And then the last item, which will be, of course, on our program, will be the parting shots. But ladies and gentlemen, without belaboring any further ado, Advocate Mabel Tisaka is a highly regarded expert in international trade and business. The person who is going to be speaking to us with over 13 years of extensive experience. She has worked in various sectors and institutions, and these ones are worth mentioning because she's going to be talking to us about these trade wars. She has worked with World Bank. Anyone who has worked with World Bank as a consultant, there is a standard below which World Bank will not hire. She's worked with the Ministry of Trade here in Uganda, Ministry of Trade, Industry and Cooperatives, and the Common Market for East and Southern Africa, COMESA. Advocate Mabel has actively participated in our Uganda's trade policy discussions relating to the AfCFTA investment protocol. This other one on digital trade is of personal interest to me. So if you're on this call, it is a good place to connect with Advocate Mabel if you're interested in matters of that digital trade protocol of the AfCFTA. But also she has participated in the AfCFTA protocol on women and youth in trade. That is why Ivan needed to first come and introduce that conversation before we bring in this heavyweight. Now, currently, Advocate Mabel is engaged with the Ministry of Trade and Industry and Cooperatives and Trademark East Africa as a trade expert on review development of Uganda's national trade policy. We are talking about trade wars, but what informs the initiatives that we take, in fact, is policy, and she's right in that space. So without reading her entire very rich CV, I've noted that Mabel is quite very passionate and dedicated about promoting regional trade. If you begin to talk to her, you may miss even lunch, you may miss even a cup of tea, because the conversation gets quite deeper and deeper when you begin conversations on trade. Now, what she's going to be talking to us about this afternoon, rather this morning into the afternoon, is trade wars, trade disruptions, and the end of AGOA. And the new international trade order, what is in need for lawyers? Mabel, over to you for your presentation. Let us give her a warm, this is a lady, so friends, let us go to those virtual clubs and let us clap to ensure that we encourage Mabel to speak to us this morning into the afternoon. Thank you so much for those claps. Mabel, you're most welcome. People are attentive and they're ready to hear from you.
Thank you very much. I've been introduced. Good morning, everyone. Thank you for attending in large numbers. Everyone that paid up is still online, so this is very impressive. Your attendance is very impressive, and I hope you can learn something, and hopefully we can also learn something from you later in the plenary session. So mine is a simple one, I should say. I'm going to talk about the new trade order and what are our opportunities as practicing lawyers. So I'll start with a global context, and as we have seen in the news, there are various trade turbulences that have disrupted trade and geopolitics in general. And some of these include the US-China tensions. I'm not going to go into the detail, but what we have to know is that the effect of all this affects, there's a ripple effect across global supply chains, and we eventually get affected as Ugandans or as a businessman in Uganda. So we have the EU digital trade regulations and regulations relating to the GDPR, the EUDR, the carbon, the CBAM, and this impacts traders worldwide. But for Africa, I think it's the EUDR that would impact us as Ugandans, because we are heavily engaged in agriculture and the export of coffee and all the other goods that require EUDR compliance. And then we have sanctions on Russia that reshaped global energy and food supply chains. We have the Red Sea shipping disruptions, resource nationalization by some countries. And of course, I can't end this without talking about the Trump tariffs. And we saw from the recent UN General Meeting that highlighted the current geopolitical wars, and indeed we can all agree that a rift is happening regarding trade, climate, and governance. And we need to be prepared as lawyers to thrive through these global dynamics. So the way I see trade wars is akin to marital disputes in terms of opportunity. Whereas it is sad, there are actually opportunities for lawyers, even in these sad times. So you find that in a marital dispute, a family and divorce lawyer will be happy. And during these trade wars, trade lawyers get a lot of jobs. And so what you need to know is that every tariff, sanction, and regulatory shift generates legal questions and disputes. Demand for lawyers as compliance advisors, dispute resolvers, policy interpreters has grown globally. If you check on LinkedIn right now, every company is asking for a trade expert or compliance officer, trade compliance officer. Why? Because they need to navigate the new tariffs that are being thrown around. When you look at Africa, for example, what are our trends? In Africa, we have the BRICS expansion. We have the African Continental Free Trade Area, that integration that has given us that volume of market and is going to form a magnet for investment and legal work. We have the digital trade growth and the green trade growth that is currently, I think all the investors and funders are currently investing in the digital trade and green trade arena currently, and most of our jobs right now are in that area. But however, I think some of you have a question, is why Africa hasn't adopted international trade? Why isn't this practice widely done in the region? And that, I can give a few reasons. That is because we have capacity gaps. Very few African firms specialize in international trade law. When I was doing my master's at Georgetown Law, I visited some law firms, and I was shocked that their international trade departments are on like 2 levels of a whole building. And I kept asking myself, what are they doing? Like, what kind of work are they getting as trade lawyers? Because in Uganda, you'd not find, you'd find commercial intellectual property, but it's rare to find a department on international trade or a practitioner specifically handling international trade in a law firm. So, and then there's the other thing we have in this country is that international and regional trade negotiation are state-centric. So they're usually led by governments and ministries. So you find that private lawyers do not accompany government, like the Attorney General in these negotiations or the officials at Ministry of Trade. But as lawyers in this sector, we've had conversations with the Ministry of Trade, and right now you can actually apply to attend negotiations on behalf of the government, although currently it's still self-funded. So we want to move to a time when we can be able to attend these negotiations and have them funded, paid for. Then the other is, of course, limited awareness. because trade in general is, even, I'm going to look at it in the angle of businesses. Businesses underutilize trade lawyers. They often turn to accountants and consultants. And with that, they think they have handled the trade legal aspect or compliance aspect. And I'm going to give an example, an actual Ugandan example. Uganda entered into a trade agreement with Algeria. I think you saw the news. And what Uganda was supposed to supply was milk and agricultural produce under that agreement. We had one company send their consignment. Everyone celebrated. And this consignment was supposed to be sent under the AFCFTA. But later they realized that they had actually used a non-preferential certificate of origin that excludes them from the benefits of the AFCFTA. And this highlights the need for trade lawyers to support this compliance process, because the things that Ivan has just taken you through, they don't happen automatic. When they say tariff-free, it doesn't happen automatic. There are certain procedures and a company has to go through to get these waivers and exemptions. And I'm going to give you some examples later of some of the work we've done so that you know that all these procedures require legal trade experts or practitioners, and companies are missing out on these waivers because they are not engaging trade lawyers. So who is currently advising? So majority of the international and regional trade law advisory and consultancy has been done by foreign law firms in the past, or foreigners in collaboration with law firms. So you find that because we have not built capacity in the area of international trade, most institutions are hiring foreign law firms. I was shocked to see the people retained by the Trade and Development Bank. The Trade and Development Bank is the bank under COMESA. I was shocked to find that there are so many foreign law firms retained by that bank, and that shows you that as we have not built that capacity. So some of the examples I can give is Ethiopia's WTO accession, which was done by White and Case. There is the resource nationalization in Tanzania was done by Herbert Smith, Free Hills. Kenya's EPA with the EU was done by Clifford and Chance. I'll not go into the details because I need to finish the presentation. And the AFCFTA, some negotiations were done by King and Spalding. So currently, I like the shift that is happening currently. Most regional economic communities have started embracing local experts and local practitioners. So I think the future is bright for us. And we've been having a lot of work in recent times because of that shift. So I'm going to bring this back home and look at Uganda. So the bulk of Uganda's trade is mostly done with EAC. So Uganda mostly trades with EAC. So whereas we talk about these global shocks, yes, they come down in terms of increase in prices, energy prices, and the rest, but the bulk of our trade is with EAC. Then after EAC, we have COMESA, followed by EU, Middle East, then China, and then the rest of the world comes in. So Uganda is obviously affected by trade wars mentioned above, but there are some that are unique to Uganda and have largely affected its trade in the region, considering that the bulk of our trade is with EAC and COMESA. So AGOA suspension affected Uganda, but I can't say it affected Uganda so much because not very many exporters were exporting with AGOA. And then we have dependency risks, and here I'm going to talk about the EU trade. Uganda is currently exporting to the EU under EU's Everything But Arms. And as I think you've seen, the president's slogan for elections is protecting the gains. Yeah, so Uganda qualified, I think in the first round, it qualified for the first round of middle income status. Meaning, if it goes through all the other two rounds and qualifies, Uganda will cease to be a low income country. And by this, it means it essentially gets out of Everything But Arms. However, is there a framework in place that can enable Ugandans to still export under the EU? We currently have no EPA in place. But however, our negotiations are underway they've been resumed. They started some time back and they've currently been resumed for the ESC Economic Partnership Agreement with the EU. And hopefully with that, and we can still continue trading with the EU beyond everything but arms. So what are the legal opportunities here? So the legal opportunities here is that as lawyers, we can advise on compliance standards with the EU. So the EU has various compliance standards, and even with the EUDR now in place, the EUDR is the EU Deforestation Regulation. We can advise on how to comply with the various regulations that are in place and then support governments with negotiating bilateral trade frameworks. Like I said, that one we are in the process of requesting for funding, lobbying for funding for private practitioners. Why? We represent the private voice. Yeah, so generally, and trade, it's the private sector that trades, it's not government. So it is very important that as lawyers, we stand together and lobby for this. And the other issues we face are public health and security shocks. So we have HIV and AIDS and Ebola outbreaks. All these strain health systems, and they strain health systems and eventually reduce workforce. So apparently, according to research and statistics, there's a high prevalence of HIV/AIDS in those border trading towns. And then conflict in the DRC and South Sudan. As mentioned earlier, these ESC countries form the bulk of Uganda's trade, and insecurity leads to blocked trade routes. And for example, Uganda's busiest corridor, Mombasa, Kampala, DRC, has been blocked, been on and off because of the DRC war this year. And then we have the persistent non-trade barriers by ESC member states, leading to blockage of goods at the border, even while they are compliant with the ESC regulations. So at this ESC level, lawyers can support with trade facilitation reforms, digital clearance, advisory, cross-border protocols, and engage in regional dispute settlement when border closures happen that violate the ESC trade commitments. And one thing you have to know, and to add on what the first presenter mentioned, the dispute settlement systems, there are dispute settlement systems set up under every regional economic community. So there's a dispute settlement system under the ESC, there's a dispute settlement system under COMESA, and there's a dispute settlement system under the African Continental Free Trade Area. But the dispute settlement system under the ESC is special, it's one of a kind. Why? Because if you have a trader as a client and they have faced non-tariff barriers because of a policy that the government has passed. I know Tanzania passes many of those. We have the East African Court of Justice. With the East African Court of Justice, it is a court of first instance. You don't need to first exhaust local remedies like other regional courts. So you can actually apply directly and within that time when that occurrence has happened to the East African Court of Justice, and you will get remedies. And these remedies include costs and damages. So currently, what is Uganda doing with the various trade dynamics and that are happening? Uganda is in the process of revising its national trade policy, the Trade Policy Implementation Plan, and the Uganda Export Development Strategy. And I am privileged to be the trade expert on that project. And the goals here are to diversify exports beyond coffee and raw commodities to enhance resilience against global shocks, leverage the African Continental Free Trade Area and ESC opportunities, and deepen the regional integration, promote value addition, and promote digital and green trade. So the role of lawyers here, you can see that we, as trade lawyers, we are engaged in legislation, in aligning rules with local regulation, and then advising on investment frameworks for businesses and ensuring compliance with international trade rules and local trade rules. So how does a lawyer advise clients? How does knowledge in trade law help you become a better practitioner? So in some of my day-to-day work, in addition to general commercial and corporate law, I advise my clients, especially investors that come to set up businesses or manufacturing plants in Uganda. I support them with navigating various trade laws. And this starts with immigration. I have seen lawyers, actually last week I was at immigration, I saw a lawyer, they had applied for a work permit for someone who is engaged in manufacturing, and they had paid $2,500 per year. And I didn't want to tell the lawyer in front of the client, but I met with them after to sort of advise them that there are laws that allow you to support your clients to get waivers for some of these things. So do you know that an investor engaged in value addition only pays yearly work permit of $400 per year? So as a lawyer, your role is to apply for this waiver, to advise the client to get this waiver, get all the compliance documents required for this waiver, and apply for these exemptions. So, and as a lawyer, you're supposed to support them, obtain the various tax deductions on their machinery that they are shipping in, and this depends on whether they are shipping it from ESC, the African Continental Free Trade Area, or if they are shipping it from China or EU or the UK, because they are bilateral agreements between Uganda and UK, for example, between Uganda and China. So how do you ensure that your client takes advantage of what is in that bilateral agreement between Uganda and China? Have you even looked at it? So if you have clients who are getting goods from China, how do you support them? And there's a time when we had a client who was getting goods machinery from the UK. There are so many benefits, very many frameworks that are in place to support that person, including guarantees to support that person get machinery from the UK. So as lawyers, we don't engage in these conversations with our clients. How can I support you get that machinery to Uganda in the best way possible, in the best cost-saving way possible, and eventually you get paid for your legal advice. So, whereas all these exemptions exist under the trade agreements and the bilateral agreements that the country signs, there are certain requirements a person is supposed to fulfill. They are not automatic. And for the trade agreements, there's what they call the rules of origin. And I know the previous speaker spoke about it. You have to comply with those rules of origin. So once my clients have started production, I ensure that if my clients want to export in the ESC or COMESA, I ensure that the way that production is being done is compliant with the market they seek to export. So I ensure that they are compliant with the rules of origin. In other words, the goods must be originating, at least 80%, depending on which agreement I'm looking at. The raw materials must be sourced within that market. So if we're looking at the African Continental Free Trade Area, the raw materials must be sourced within that area. So, and then we have to ensure that they meet the standards that are required. I'll give an example. When the bilateral agreement was signed with Algeria, Ugandans all of a sudden had to ensure that they are halal compliant, and which they were not doing. They had to add those certifications, which they were not doing. So you have to make sure that your client meets all those requirements, so that when the planning and the good is out, they are able to access these markets with low tariffs and or tariff-free. So I'm going to give you a few examples of past Ugandan trade-related disputes that have been handled by Ugandans. We had a dispute relating to the ESC sugar, which was in the period 2019 to 2021. Kenya restricted sugar and milk imports from Uganda, citing standards, and it's Ugandans that dealt with this matter. It escalated the matter, the lawyers, Ugandan lawyers and trade experts escalated the matter to the ESC Council of Ministers, and it was resolved. And then there was the fish ban, the fish export ban. Here, what the country did, the issue was EU banned Uganda's fish exports over sanitary concerns. And at that time, we had the cholera outbreak, and there were poor standards on Lake Victoria. So Uganda's response in this case was to work with local regulators, lawyers, and compliance experts to reform the fisheries law. So as lawyers, as trade lawyers, you're also engaged in policy, like I've explained. So the bulk of my work is either in compliance and or policy. Yeah, so then the oil-related disputes, these have been many. Several disputes between Uganda government and international oil companies. There is Talo Heritage over capital gains tax and production sharing agreements. Here we've had Ugandan lawyers, URA tax specialists work alongside international law firms in arbitration and negotiations. And this shows you the power of collaboration. So sometimes collaboration is better than having an international expert solely handle the job. Then, so the gaps that we have now are in negotiations. Again, we often rely on foreign consultants, especially with the WTO. And then the other challenge of lawyers specializing in trade law, most lawyers believe that commercial law encompasses trade law, but not always. So there is good to have a clear understanding of trade law, because at the end of the day, you are going to trade, you're going to look at these, the protocols that Ivan was talking about. You need to understand them, you need to be able to interpret them. And then, so what I would want you to take away today is that trade law is not theoretical. It shapes market access and national competitiveness. The next frontier of lawyers, of Ugandan lawyers, and the next frontier for me is training Ugandan lawyers to lead in the African Continental Free Trade Area, COMESA, WTO-related disputes and negotiations, rather than outsourcing international law firms. So I think as trade lawyers, we need to take our space. I know trade lawyers in other countries. I've had the opportunity of moving in other countries, and I have seen trade lawyers take their space, but I feel in Uganda the time is now for us as trade lawyers to take our space and take over our practice. I think we have handed over our practice, I don't know to who, but we need to take it back. And then, again, there are so many emerging legal opportunities, and these include drafting cross-border contracts, advising on dispute settlement mechanisms under the various regional economic communities, advising Ugandan businesses on rules of origin, tariff schedules, customs, NTBs, non-tariff barriers, arbitration and mediation under the various protocols and bilateral agreements. Arbitration is one way, but all the protocols and the agreements always provide for mediation. So mediation is also another mechanism. Then policy advisory and all policy formulation is also another area you can look at. And then I'm going to skip this and go to the last. So the lawyers of tomorrow, the trade lawyers of tomorrow in Uganda, we need to move from being from drafters to strategists. So we need to position our businesses in these turbulent times. So we need to be able, so as a trade lawyer, you need to be able to be a trade compliance expert. So you need to be able to advise your clients on all compliance-related matters relating to the place where they are buying, either buying their machinery or going to sell their goods. So depending on what it is, if it is the EU, you need to be able to advise them. If it is China, you need to be able to advise them. If it is EAC COMESA, you need to be able to advise them. Then cross-border dispute resolver. You need to be able to be engaged in arbitration, mediation, and regional courts. So meaning if you're probably doing a cross-border business transaction, you need to be able to advise them on arbitration, where the seat will be, which rules you'll follow, and all that. Then policy shaper. You need to be able to advise on policy formulation, because this field is still green. New policies are being formed. Currently, COMESA is working on digital trade policies. Uganda is working on is advancing in its digital trade framework. So new policies are being formed. We're just getting integrated deeply. So there's a lot of work around policy formulation. Then sector specialists. So there are certain sectors that you need to try to understand if you don't know them. And that is the digital economy, fintech, climate, and all green trade, because these are closely related to regional and international trade. So, so now, because of this multipolar trade world that is emerging, Ugandan lawyers must go continental, specialize in cross-border trade, arbitration, and policy engagement. Where there is disruption, there is legal opportunities. Lawyers are the navigators of uncertainty. So let us be called to action. We should build our expertise, position ourselves, and engage and invest in new frontiers if you haven't. Thank you very much.
Wow, wow, wow. That is Advocate Mebo. Someone online is saying I should call you Counsel Mebo. Yes, I think when they hear advocate, it does not resonate well with them. Thank you for those virtual hands of applause. Thank you, ladies and gentlemen. Those are, hey, some people are even giving you cones of ice. Hearts are going up.
I love
Okay,
it,
now, now hearts are going up. Sorry, Emma, sorry, Ivan, we never got hearts for you. But that is where we are at when it comes to this issue of international trade. The participants are already saying online that this is a complex area. Some are saying, yeah, there is an issue of capacity building. Someone had already proposed, shouldn't LDC and Uganda Law Society team up maybe to come up with the kind of course to build capacity in this area. But one, as we are saying that, we may think that maybe yourself, Mebo, Ivan, and Emma, you fell from heaven. You fell from somewhere. You're not maybe Ugandans. You're not even maybe trained here. The first question, in as far as capacity is concerned, what are you advising a person who is contemplating to become a trade lawyer? It's going to be an open question to each one of us before we delve into the specific questions, because the moment each of you was hinting on an issue of capacity, you were seeing eyebrows go up. And the first question is, I have come to this webinar, I have heard all these complex concepts, they seem to be interesting, they are building some intrigue and they are building some curiosity. What do I do next? How do I become the next Emma? How do I become the next Ivan? How do I become the next Mebo? So we will begin, but Ivan, we can begin with yourself, then we'll come back to Mebo, and then we go to Emma.
Should have started the senior academic. One is the dean of a law school. Anyway, I think it's really about capacity building, but also maybe love for the area, because also I think lawyers many times they fall victim to what is trending. What is trending, if there's a new area of law and there's money, or see some guy driving a new car, then you also want to specialize in that. But I think it's also, because I think trade, also because of its cross-cutting nature, the WTO literally has arguments on literally everything, agriculture, procurement, what. So maybe inevitably you might argue that every lawyer should be a trade lawyer in one way or the other, now especially with the advent of the FCFTA, which might more or less at one point have protocols on just about everything. Every lawyer should have an interest, because also I think trade really runs the world. If you're practicing commercial law, some of those laws are premised on international agreements, international trade agreements and what have you. if it's even matters concerning climate change these days have become very controversial. So I think for me, capacity, but also one love for the area, but also like I've said, inevitably, when you mention something like digital trade, for example, we are all more or less tech lawyers, especially with advent of things like ECMIS and what have you. So you must be interested, without a doubt. Increasingly, they're going to have clients playing across the borders, so I think every lawyer should inevitably become a tech lawyer. What I think where you can go for now, yes, in Uganda, we have a few challenges here and there. I think also having been a lecturer, I know this perhaps, we teach trade law from the old documentary credits, FOB, and I don't know what else style. I think this policy, there should be a sort of a rejigging of the curriculum to include some of these new areas. I think also now some universities, like Uganda University has a bespoke program on East African community law. So maybe universities should also be creative and create a special program on FCFTA law, away from the normal, trade law as we know it. So something like that, yeah.
Yes, thank you, Ivan. And now we want also to learn, how do I become the next Emma? You're a dean, you are an executive director, but all these you seem to have a very strong niche when it comes to integration, and you speak quite passionately about it. Where does someone begin?
Okay, thank you. I think since I'm speaking to lawyers, the most practical way of learning more about integration is to actually seek working opportunities in this area. So we have, for example, exchange programs offered by EU institutions. Because when you look at the most integrated area, it's the European Union. It's been going through integration for about 50 years. Well, we started integration probably the same time as them, just that the East African community then collapsed 10 years later. But for them, they continued. And we re-emerged with the ESC again in 1999, about 30 years later. So they've really, really done well with integration. They've gone through all the loops and hurdles. And many of their institutions now offer what they call traineeships or exchange programs. For example, the European Central Bank, the European Court of Justice, the European Commission, the European Parliament. Lawyers can look at these websites and see how to take up this traineeship and exchange programs on those. Then they will see integration in practice. Getting an opportunity to work, say, in a customs authority of a European country, even just for an internship, can help one see integration really in practice, even just for a month or two. And so we can advise Uganda Law Society, for example, to look for these opportunities, because Uganda Law Society would have a better foot in than an individual. So Uganda Law Society can liaise with these institutions, not just in Europe, but also in the Caribbean, in Asia, and within Africa. We've had quite good mileage with COMESA, for example. AFCFT is doing a terrific job, and Uganda Law Society can actively seek exchange, internship, traineeship opportunities with those institutions. I think from a practical level, that will be the best. But from an academic level, speaking as an academic and also on the back of my brother here, Ojako, it will be to study these things at a deep theoretical level. I had the opportunity to study European Union law, and so that helps you to study basically the future of where ESC law is going, or some of the premise that that ESC law is anchored upon. And so courses out there on EU law are so many, on open universities, on Coursera, on all these virtual online course offerings. Many of them are even free. So, lawyers can take up some of these opportunities to study another integration legal mechanism, like European Union law or the Caribbean community, very advanced as well. There are many courses on this. There are courses on WTO law online. Even on the WTO website itself, there are free courses on WTO law. So these resources are out there, and from the theoretical and academic level, lawyers are encouraged to take up these short courses. And then at a deeper level, maybe taking up master's programs and PhD programs on this area. many universities, especially in Europe and America, are very interested in integration in Africa, perhaps even more than Africans.
Do you know probably of any opportunities? Because as Mebo is going to come in, she did say you can apply to be part of the negotiation team, only that you have to fund yourself. People would be interested to do the courses, people would be interested to go in these areas. Are there any tips, one or two, where you say begin looking in these areas if you're interested to take this line of study?
Yeah. Yes, universities, especially in Germany, Netherlands, and Norway, are very keen and have many programs. So I can say specifically where I'm doing my PhD is Leiden University. It has programs on EU law and has scholarships and funding for lawyers who want to do, especially PhDs on EU law. They are very, very, very welcoming. As I was saying earlier, they are more interested in ESC knowledge than, or on FCFJ knowledge than Africans. As has always been in the past, you'll find that in the White House in America, there's a department on Africa.
We filled have a with department on US.
Whereas here in our state offices, we do not have departments on the US or in Europe. So they study us, which enables them to continue being ahead of us. So I think for us to catch up and even overtake, we need to also take studying them very seriously and then know how to do it better.
I'm going to come back to you, Emma, because there are quite some difficult questions that people have posed. But maybe we are talking about international trade in times of crisis, lessons and opportunities for lawyers. I see quite a number of highly reputable practitioners. We have doctors online, we have retired judges online. We have even, for a webinar such as this and the kind of people it has attracted to participate, the question is, where does someone begin at whatever level of career that they are? They're a senior lawyer, they're a junior lawyer, but they're interested in interrogating this issue of opportunities that they can get in international trade. Where does someone start before we get into the technical questions?
Okay, I'm going to first start with a young lawyer. There is a certificate in intra-African trade actually, and it's free of charge. It's done by Afreximbank in conjunction with the ITC International Trade Center. So just Google certificate in international trade, ITC Afreximbank. It will come up. Once you do that session from beginning to end, you'll do a small exam. It's not difficult. I've done it for purposes, because I've been a trainer for the ITC before. So I've done it because I essentially took people through that certificate, through that entire module. So once you do the training, you'll actually get an actual certificate from Afreximbank and ITC in international trade. You'll get a document for that, and you'll do a small exam. It's not very hard, and it's free of charge. It comes at no cost.
How long does that certificate run for?
You can even do it in a week if you have time. It's online. You go to the next until you get to the end. But it will take you through everything international trade, especially African international trade. It focuses on intra-African trade. Yes, so for young lawyers, you can do that. And then for those who are already in trade, I know most people study trade and then they don't practice it. There's a lot of work out there. I think what we need to do is sort of collaborate so that we can share opportunities whenever we get them. Whenever I get opportunities and I can't handle, I always share with people that I know are looking for opportunities. So maybe we can share opportunities. International trade requires a lot of collaboration. Some of the work, you'd need an economist. So we sometimes have to create consortiums and get economists on board to do some of the economic work aspect of the project. So the work is immense. If you went to I think 2 months ago, there was every organization was calling for consultants or had bids, and it was all international trade, digital trade related. So the work is immense. I just think you just need to stay online. You just need to stay online, look at all the regional bodies, what work are they pushing out, look at the development partners, because some of the work comes from people like Trademark Africa and World Bank and other development partners, look at the work they're doing, and then there's day-to-day advisory. So the clients, we already have these clients that are engaged in international trade. We just haven't sold that service to them. So personally, I sell the service to them. I tell them I have a write-out, some sort of profile where I show them what I can do for them. And once they see the advantage, for example, the client I got, and I had to transition them from paying $2,500 to $400 per year. Once they see the advantage, they'll even pay you more than you expect. So that's, you just need to sell that service to your clients, because we have clients that are exporting under the ESC. We have the clients that are exporting under COMESA. We have the clients that are exporting in the EU, but we have not strategically placed ourselves or told them that we can give them that extra compliance services in relation to trade. So we just need to sell ourselves to our clients and ensure that they give us that work.
So Mebo, as you were mentioning that certificate again and again, already I see online that Bagonza Morini is saying, please pardon on what is that certificate which is free, I can do in 1 week or so. I've built my capacity and I'm setting myself up to be a trade lawyer. Please pardon on it again.
Someone has posted it in the chats. You've posted it, right? Is it that one?
It's just a link, but
Yeah.
they need a pardon. On
So
what that
that's
certificate is.
it's certificate in intra-African trade, and it is offered by Afrexim Bank and International Trade Center. So if you Google certificate in intra-African trade and Google Afrexim and add Afrexim Bank and ITC, it should be able to come up. And I think it's on that link that you have posted, Lanston.
Yes. Okay, so you just go to that link, but also this is why.
Oh, sorry, it only came to hosts and panelists. He's going to repost it to everyone. He's
Yes.
going to repost the link to everyone.
Yes, but as you Google, this is one of the reasons why we do capacity building. When you Google the certificate on intra-African trade, ITC is International Trade Center. Yes. And Afrexim Bank, you'll be able to have those links come to you and then you follow. But also the opportunity is that this is intended to be a networking, it's intended to be a networking place. So when you know that Mebo is an expert in this place, Ivan is an expert, you know, Emma is an expert. Online, we have people who are also other experts. The speakers are not the only experts. There are other experts as well. So you pick up someone's contact, find out someone's office. Lawyers, we are good at effecting service. So you can serve your presence by saying, I have come to meet you, Mebo. Can you give me 10 minutes of your morning or afternoon? Ivan, can you give me just 10 minutes? Or Mr. Emmanuel, can you give me 10, 15 minutes? What can I do in this area? Like we said, some of these concepts are very technical. They cannot be discussed in just a few hours. But you have sparked, all of you, as the three speakers, you have sparked a very interesting discussion online. I see there have been some comments that have come in, but also some observations where I want to pick your mind as the respective people have brought this to light. And I'll begin with yourself, Mr. Sebijo Emmanuel. This issue of sovereignty and integration. The question is, how can partner states practically balance national sovereignty with the doctrine of precedence of ESC law, especially when domestic political interests conflict with treaty obligations? Sometimes in the places where we are doing lobbying for policy, organizations, mostly civil society organizations, are relying on advice of lawyers of how can we lobby better. But if we don't understand how do you lobby to ensure that you swing the political will to a certain direction, you end up having even the advocacy work being done by civil society organizations not being fruitful. Now that we are in a webinar of talking about 25 years of ESC, what are your thoughts on how partner states can practically balance that issue of national sovereignty and the doctrine of precedence, if any practical solutions come up?
Okay, thank you, Laston. And I think the the most important device for balancing those two are the national constitutions. Because national constitutions are supreme no matter what, whether there's an international treaty or it's the ESC treaty, and the ESCJ and the national courts equally have also made it very clear that the doctrine of precedence shall not apply to the national constitution. So, as a balancing act, we can always revert to our national constitutions in terms of maintaining the democratic structure of a state and not having it kind of influenced or affected by the external ESC treaty. But it's a balancing act, and I think the author of the question is quite right in calling it a balancing act, because national constitutions sometimes can prevent the enforcement of certain ESC treaty obligations, but the drafters of the treaty were very careful to really do a very good job not to have provisions that conflict with national constitutions. So already the treaty and the protocols are inherently balanced. And so it's for the states to actually recognize that balance and not insist on a tilt in their favor. It is a balance between the doctrine of precedence and sovereignty, and that balance is achieved by the ESC treaty and the protocols. Because requiring states, for example, to allow all people in those states is not very extreme, especially because the ESC Common Market Protocol is clear that citizenship will remain the province of the state. So the ESC treaty does not confer East African citizenship. Actually, there's no such thing as an East African in the legal sense of the word. We are all citizens of partner states of the East African community. So that balance, where we're maintaining national constitutions as the authors of citizenship, whilst allowing free movement of persons for the economic benefits under the Common Market Protocol, is inherent in the setup of the ESC framework.
And just to pick up from that, I see Dr. Noria had given quite some comments on the processes of what laws have been passed by the different partner states when it comes to ratification and domesticating some of these instruments in the ESC. And I want to bring in Ivan here. Ivan, you talked about the dispute resolution mechanism under the AFCFTA, and there is a question here on issue of how can we practice across borders. The question is, since the AFCFTA liberalizes trading services, including legal services, what frameworks or recognition mechanisms exist, if any, to allow lawyers to practice across borders in Africa? Mabel also was talking about...
It's not express, despite the provision on mutual recognition under the protocol on trading services. There's no express annex that's saying legal services. It tries to play under business, and lawyers are trying to say they will fit into that. But perhaps, and thankfully, it is still a living document that we can, still front our ideas and see how we can embed it or even, push for our... So there's no express provision, and that also ties into the discussion on mutual recognition of lawyers when it comes to East African community. I don't know why, well, maybe for reasons justified, why our leaders want to protect legal services that much. So it's not really express, but for now, the argument is that we are covered under business when it comes to the annex on trading services. So perhaps you can exploit that and be able to move. But again, they're not clearly defined. For example, when it comes to the EU, and Emma here is the expert, there is a particular instrument that says, for example, you come here, you'll do advisory work, you won't litigate. So it's not exactly clear yet as far as the FTA is concerned, despite the fact that there is that opportunity. So we need perhaps, again, in line with opportunities for lawyers, to fight for our space as far as this is concerned, because there cannot be FCFTA without lawyers. It cannot be FCFTA without advisory, without dispute resolution. I don't know if I've answered all the questions. Is there something else? I've given a sort of pessimistic view, but there is a provision of mutual recognition, which I believe can be worked on slowly in order to enable us to get into these spaces. Yeah, but properly needs to be defined on what we can do and what we cannot do.
You have been very bold and frank, because sometimes when we are talking about the African continental free trade area, the expectation is that everything is straightforward. I can walk into any country in Africa and I would be recognized as a legal practitioner, but that's not the truth. There are rules that govern movement of services and how you do supply of services. And when Emma was talking about the different rights under the ESC, and specifically when it comes to the Common Market Protocol, when it comes to supply of services, I know there are about 4 modes of supply. So as Ivan has encouraged us to invest in self and then learn, it is possible to be supplying a service when you're based here in Uganda and you're giving a legal service to a client who is established elsewhere. There are those different modes.
Just one more.
Yes,
One
yes,
minute.
please.
Just of course now beyond that, the FCFTA beyond a typical purist trade lawyer is a cross-cutting document or agreement that is going to allow lawyers, be it finance lawyers, be it labor lawyers, be it environmental lawyers, to tap into these opportunities. If for example, you looked at small things when it comes to sanitary and phytosanitary measures, that already is bringing health lawyers, or do they call themselves health lawyers or public health lawyers? The likes of, I've seen a gentleman who was an NGO that fights for food rights. He's called, forgot his name, he used to work with Sehad back in the day. So things like those. So phytosanitary and sanitary measures are important when it comes to the goods that you allow, especially food. Do they meet health standards? Do they meet, are they going to bring diseases into the country? So there are standards that have been developed when it comes to things like those. Labor, environmental, climate change. There's a debate on carbon credits and Africa. The current carbon market legal regime is not fit for purpose as far as Africa is concerned, because it creates unnecessary burdens. Kenya had to evict an indigenous tribe from a forest because they had certain obligations, some investor who was going to use that forest for carbon credits. So things like those. So we need bespoke solutions as far as all of this is concerned, and it calls for all of us. IP, competition, digital trade, tech lawyers, finance. The AFCFTA, as supported by Afrexim Bank, has a 10 billion, I think it's called an adjustment facility for state parties to be able to tap into the FCM market. That calls for finance lawyers. It has something called the PAPS, Pan-African Payment Settlement System, that is trying to revolutionize the real-time settlement growth system and create real-time solutions as far as settlement of money is concerned in Africa in local currencies. That calls for tech lawyers, fintech lawyers, finance lawyers. So all these opportunities are there, and really it's up to you to skill up and tap into the opportunities. I've seen Uganda is not even participating in the PAPS yet.
Yes.
So as a lawyer, please tell Bank of Uganda.
Skill up and then tap into these opportunities. I've just shared, Emma has been very kind to share quite a very extensive article that he did when it comes to the issue of mechanisms of cross-border legal practice. It's an article which was published in the Journal of ULS, and a link has also been posted. You're able to download that article. I want to bring in Mabel at this point, and there is a bit of an interesting question. It seems to be forward-looking, because you've talked about us accompanying and applying to accompany government in these negotiations. And the question is, as the world is shifting towards a multipolar trade system, as such, you're looking at AFCFTA, BRICS, WTO reforms, what role should a Ugandan lawyer or even an African lawyer play in shaping policy and representing their country's interests in global trade negotiations? Now, that may sound like a very heavy thing, but if we are being forward-looking, I believe it's possible to get into these rooms, and we want to hear your practical thoughts. Before we pick the hands, we have some people who have their hands online, and we are going to be picking them shortly. But what role, surely, should a Ugandan lawyer play in shaping these trade negotiations?
Thank you very much. What lawyer should Ugandans play? About cross-border practice, I think we saw Martha Karua. She was able to come to Uganda, and eventually the Law Council allowed her to represent Besigye. So it's possible. And then what should we do? Yes. What should we do? Yeah. there's a lot to be done, and I think, like I said earlier, whereas in the Western countries, in some of the African countries, the private sector, who are the private lawyers, are heavily engaged in negotiations for treaties and agreements alongside government. In Uganda, this has not yet been achieved, and I think maybe the Radical Nuba can also help us be radical in that area. But yeah, I think as trade practitioners, like I said, we need to stand together and lobby for that, and see how we can be engaged, but not be engaged without payment. Right now, it's possible. It's actually possible. You can, usually when they write these letters, let me give an example from the African Free Trade Office. When they write these letters, they invite the ministry officials, and they usually sponsor only 2. They can invite a delegation of up to 6 people, but only 2 are sponsored. So meaning if only 2 or 3, it depends, are sponsored. So meaning if 3 extra people want to go, you'd have to self-sponsor yourself to attend the negotiations. So we need to create a framework, or we need to create a framework where we can actively participate in these negotiations and get paid for it. And then when it comes to policy is a bit easier. Why? Because if you see a need in society, especially relating to trade, and it can be capacity building, for example. There is a lot of funding out there. There's a lot of funding. You can come up with a proposal and then you request for funding. There's a lot of funding in the policy arena and or capacity building arena. So you can come up with a proposal and go to the bodies that are currently funding.
I want to chip in a question there on funding. Bitature Vincent online, he is asking, why is it that Bank of Uganda, the gatekeeper of international trade in respect of Uganda, is not involved in training and sensitizing lawyers? Now, we don't have any representative from Bank of Uganda on the panel, but you've talked about funding and proposals. How would that work, Mabel?
I don't know that Bank of Uganda has that mandate to train lawyers, but I don't know that they have that mandate. I would first see what their mandate is in terms of capacity building. But like I said, I'm glad we have the ULS that came up with this CLE. This is also another capacity building session. And we have the ELS that does capacity building sessions. Actually, last week we had a session on the ESCJ alone, which was really good. So we have various capacity building sessions, but then also there are regulatory lags that we have that can easily be funded. Yeah.
So thank you, Mabel. Now we have 2 hands who are online. There is another question from Akulo. That one has been deferred to the Secretariat. Akulo is asking, I am humbled to be part of this. I need to know when the then CLE points will reflect on the ULS portal. That has nothing to do with international trade and crisis, but that has been picked up by the Secretariat. The 2 hands online, I see Dr. Hilda and Blaise Amanya. I will ask the technical team if we can have Blaise Amanya had their hand up for quite a while. If you're in a quiet place and you're able to unmute, we'll give you talking rights. Just ask your question directly, and then we'll go to the next hand, which is Hilda. Blaise, please, you can unmute your microphone. You've been given speaking rights. Make sure you're in a quiet place, and then we'll be able to pick your question. We hope the hand was not raised in error if you were trying to give Mabel flowers or a heart or a hand of applause, but the hand has been up for a while. Yes, Amanya? Okay, if we can't get Amanya, since their hand was up for a while, we will move to Dr. Hilda. Dr. Hilda, you have your hand up, so we will pick Dr. Hilda. You can unmute. You've been given speaking rights. You can unmute and then make your contribution or ask your question. You're welcome, Dr. Hilda.
Thank you very much. ULS, this has been very informative. I was that participant that sent hearts to Mabel. Being the only lady in that team, I was so inspired by her practical examples, and yeah, she really brought fire. Not that the others didn't do great justice, but she added a little flavor, I think, of a woman into the presentation. Thank you so much. Mabel said something. My comments are going to be mostly directed to Mabel. She talked about collaboration with permission of ULS. I would like to meet you after this. I am a research and publications officer at the Law Development Center. And I hope maybe the members remember that sometime not long ago in June, we had a summit, peer review summit at the Law Development Center. And the main issue was, how do we take legal education and training forward? How do we reform it in a way that it can be able to, among others, enable the forthcoming lawyers fit into the market? So in terms of skilling, one of the things that we could think about is working together to see, can we come up with a concept? As a researcher at LDC, I could come and then, based on your time, we work out a project. I'll take that on, knowing that you're into private practice, and that requires a lot of time. But we could come up with a concept on that I could sell to the director in terms of how do we fit this within the current curriculum of LDC in terms of value addition and in terms of ethics, in terms of the resource personnel, the course implications and things like that. But also, in addition to that, for the young lawyers, I did my master's and my PhD, my master's at the University of the Western Cape on scholarship, international trade and business law, and sometimes it's international law, international trade and investment law, depending on the availability of the experts who are supposed to come and train. And those are scholarships offered by the World Bank, the World Trade Organization. And for those who want to do their masters, it is offered interchangeably between University of Pretoria in South Africa and the University of the Western Cape. So if this year it is offered at University of the Western Cape, the next year it will be offered at the University of Pretoria. So you can apply for your master's. Scholarships are given, and it's a very good scholarship with experts from World Bank, from the World Trade Organization, from the African continent, very rich in terms of expertise and knowledge. And then there was the other thing that I found very interesting, on the fact that it's true there are very many lawyers that are not involved, and particularly maybe because it's because of the way the course is oriented, or the depth of the course, the course module or unit within the undergraduate level. Someone mentioned that the focus has always been on maybe Incoterms, or basically the peripheries or the theoretical aspects. But the three of you have brought in a very rich aspect on the practical elements that we need to bring into the curriculum. And I remember when I was doing my master's and after my PhD, I reached out to one of the prominent law firms in Africa, but based in South Africa. They did tell me that no, international trade does not bring us a lot of money. So I agree with you, Mabel, that yes, in Africa especially, there is very little attention being given to the richness that that particular subsector can bring to the lawyers, or how lawyers can add value to it. And then in addition to that, we have, in my own experience, I have seen that elements or issues of compliance are being handled so much by those who are called clearance agents, okay? Lawyers are there, but within the Ugandan market, or even most of the African communities that are involved in cross-border trade, you find that it is mostly clearance agents that are handling cross-border issues of compliance and risk. So I really thank you, ULS. This was really, really, really very enlightening, very empowering. It's like a refresher course for me. So thank you very much. Yeah, I would like to collaborate more. Thank you.
Thank you so much, Dr. Hilda. We were saying that when a doctor says that she has been taken through a refresher course, I believe that our speakers are really pinching on themselves and saying how lucky they must be that they had doctors on the webinar. We have had a very wonderful audience, and we're just going to go into parting shots by our speakers. I see people like Dr. Noria were very, very active, posting, sharing knowledge as well. Dr. Hilda, the comments that you have given. In the meeting that you're having with Mebo, we have agreed that in meetings where money is being signed, I can come witness. I can come witness because she has been getting hearts. She has been getting hand claps. You guys have been a very wonderful audience. When the flyers were going out and we were circulating them, some people are asking, is this another webinar just to get CLE points? We can agree that from 9 to midday, it's been a time very, very well spent. I will ask the technical team that the hands are lowered because I believe we've been able to, and then the people are muted so that we can get back to our speakers. Time has not allowed us to be able to pick out the posts that were made in the chats, but I believe we were reading them as we're going through the presentations. And then secondly, Mebo has been kind to share her contact, but also Emma's contacts are very, very well known. He's available online. Ivan is also available online. The opportunities that are being shared. The moment you introduce yourself to any of these speakers that I was in the webinar where you made a presentation on this, I seek an appointment with you to speak about this further. They are very, very lovely people. On LinkedIn, you're able to catch up with them. That's where professionals are exchanging contacts and having these discussions. Now, gentlemen, we have been just castigated for having one lady on the panel. So we are going to make sure that as we are coming to the close, she's going to give the closing remarks. So we are going to begin with yourself, Ivan, to give us your parting shots. You can see the kind of conversation you sparked. And I believe there are training opportunities, there are collaborating opportunities, there are concept notes. People are very hungry for knowledge. What are your parting shots on this topic that we have been discussing on international trade in times of crisis, lessons and opportunities for lawyers? Your parting shots, Mr.
Quickly,
Ivan.
just to quickly add voice what Dr. Hilda said. A lot of what she has called, you should call them brokers. Yeah. The brokers, it's because of the multidisciplinary nature of international trade. When you go to some institutions, they offer an MSc. It's not just lawyers. For example, the one at the Trade Policy Training Center in Africa, in Arusha, under the auspices of Lund University. It is an MSc in international trade law and policy. And you'll find more economists and people from different backgrounds there. So those guys eventually get the knowledge of international trade and can advise clients. And indeed, at the IBA Africa Regional Forum, when we hosted a masterclass on the FCFTA protocols, one of our speakers, who's also ironically a lecturer at TRAPCA and also now the chief of staff at the FCFTA, Dr. Makong, said he never sees lawyers in international trade negotiations. And maybe we can also add voice to that. They're usually people of different backgrounds, but because they have knowledge of international trade law, because of its multidisciplinary nature, they take center stage. So in line with that, I would part by saying, let's take our space as lawyers. Indeed, Dr. Hilda said there are actually very many Ugandans who have done those courses in South Africa. But they come back here and go into the normal practice. And you can't blame them, the economy. People have to survive. So why should I go into these high-minded things of international trade in goods and MFN when there's no money coming through? So you can't blame them. So really, let's take up our space by one, being more aggressive. And also, I think it's high time we stop working in silos as lawyers and came together and pushed our agenda. Thank you very much.
Thank you. From yourself, Mr. Sevijo Emmanuel, parting shots.
Thank you so much. Thank you, Laston, for such a wonderful moderation, and also thank you to the Uganda Law Society for hosting this and for having us. In terms of parting shots, I think for me, from the ESC perspective, we have to call upon lawyers. ESC law is law. ESC law is a source of law in Uganda. Laston earlier referred to Section 14 of the Judicature Act, which outlines the sources of law and which judges are accustomed to calling out advocates upon. And I just want to remind that that section provides that the written law in Uganda is a source of law. And if we consider that the ESC Act of Uganda, that's the East African Community Act, CAP 187, which imports ESC law into the Ugandan legal system, if we consider that that act is written law, and therefore a source of law under Section 14, then by that act importing the entire ESC law into Uganda and giving it the force of law, I think we can conclude that ESC law has the force of law in Uganda. So please don't be discouraged by any of the assumptions that ESC law is not being implemented, that the judges won't listen to you. It is law. It has been cited and successfully implemented in many domestic cases, in many regional cases, and will potentially be an avenue for the implementation of AFCFTA law later on. So I encourage lawyers to advise their clients and be courageous about enforcing these ESC law rights, especially from my part, the economic rights. I think there are enough advocates for human rights and governance provisions of the ESC treaty. I want to advocate especially now for the economic provisions, for the economic rights. Please take them up. Please take them up, and please also advance them in much the same with much the same energy as we're advancing the rule of law, democracy, and human rights provisions. Because ultimately, I think by giving us economic freedom, we can achieve a heightened sense of social and regional livelihood. Thank you.
Wow, very good parting shots. And Dr. Hilda and others, we are welcoming the only lady. This is where the hearts come out again. But I'm seeing Anthony Arinitro is saying, appreciative that ULS is taking us outside our routine. You see the kind of discussion and the kind of reception that people are having. Yeah. The retired Justice Wolayo is saying, thank you presenters for excellent presentations. And doctors like Dr. Hilda are saying, thank you for a refresher course. Ladies and gentlemen, parting shots from Council Mebo. You're welcome.
Thank you. At the beginning, I compared trade wars to a divorce. But unlike divorces, as trade practitioners, we build. We are international development practitioners. The work that we do leads to economic development. In other words, as a trade lawyer, if you go to all your small-scale coffee growers in your village and got them to aggregate under a circle and got them to export, trade is so big, but let me say this because I like saying it because I know most lawyers don't take advantage of it. So under the African Continental Free Trade Area, we have what they call the Trade Observatory. So the Trade Observatory is a market, it's a market platform that shows you that in Ghana, this is what is required. It helps you do the market assessment and the market research on your behalf, online. This is how far our digital trade has gone. Then, in addition to that, we have what we call the African Continental Free Trade Area has a B2B marketplace. It's called the ATO. No. It's called the, I've forgotten the name. I don't know why it's escaped my head. But it's an app where if you are in Mbale, for example, and you post your coffee, it's like the Amazon of Africa. It's called ATEX. Thank you very much. It's called ATEX. If you are in Mbale, you can post your product, and someone in South Africa will see it and order for it. So cross-border trade is no longer as hard as we used to think. It has now been simplified, and what is happening currently, the ATEX is going to be connected to the national digital, e-commerce digital platforms that are being created all over the different African countries. So it's no longer complex. It means someone in the village can be able to market their products to everyone in the entire region and beyond, because once you post it on ATEX, even someone in America can see your product. So our role fosters economic development, and it's such an honorable role to do as a lawyer. It's refreshing to do something does not entail taking someone to prison, or but making someone better, making someone literally better. Now, there's a time I went to Jinja and Iganga, and I was doing a trade workshop, and I remember I met those ladies. They didn't have businesses. They're never registered, but they were artisans. They had so many very beautiful products, and I connected them to some of ITC projects, and they were able to, on top of registering their businesses, they were able to take part in the African Continental Free Trade Area Trade Fair. And I remember those ladies getting on the plane. They would send me photos after 1 minute. Oh, we are here. Now we've seen this. Now the joy you get from seeing someone become better economically, from seeing someone empowered, is much better than money. So this practice is not only about money. There is much more fulfillment that you get beyond money. So Dr. Hilda, I am very, very grateful that there's someone passionate out there like you, and who is doing something as important as guiding the next generation. And it will be an honor, really, to collaborate and meet and get this capacity building started. So I'm available. We can meet and talk. And to everyone, thank you for coming. Thank you for being part of this. Again, Ivan stated earlier, let's not end this conversation today. Let this conversation continue. Let us take this further. Let us find ways of meeting, of collaborating, and of taking up our space as international trade practitioners. Thank you very much.
Wow, wow. You've crowned it up well. It would be nice if we gave the lady on the panel a good hand of, the hearts have come back again. But friends, as we are coming to an end, I am seeing here Mr. Hussein Kashilingi, quite a very well-positioned practitioner. The comment you've given is very encouraging. He says that this has been a very informative session. That is from Mr. Hussein Kashilingi, and that is very, very encouraging. Now, Ntegereza is saying, apart from advising on compliance, advocates can be conciliators, arbitrators, mediators, among others, under the African Continental Free Trade Area. There is a saying, Munji Michael is saying, but counsel, what is beyond money? Yeah, and that is why we need to take this conversation out of the webinar further. What is beyond money, and so on and so forth. It is said that good things end while they are still hot. It being a Friday, we don't want to keep you any further, but you've been a very, very excellent audience from the time we started. Yes, from the time we've started, we have not lost any person dropping off. Instead, more people have been joining. We promised we'll be done by 1, and I believe it is way before 1. It's still just midday. And we want to say thank you so much. The presentations are with the Secretariat, and they will be shared via email. From ourselves as the team that has been doing this webinar, we want to thank the Uganda Law Society, the Radical New Birth, the Secretariat, and everyone who has been behind this, the media team, the people who are behind the cameras. Thank you so much for giving us a great experience. We had the privilege of having our speakers come physically here, and we believe it has been a better experience than the network breaking. We've been able to follow the conversation very well. Allow us to say asante sana and wish you a very lovely afternoon and a very lovely weekend. We'll be seeing you probably in the next webinar. And like Dr. Hilda said, I'm already assisting, maybe so as you're meeting in those meetings to discuss concepts and work. I'll be right there. Thank you so much from myself. Laston Gulume, it's been a privilege to be with such brilliant minds, and it's been a privilege to have all of you. Allow us to say, have a lovely afternoon, and thank you so much. Music is food for the soul. There are people who leave the webinar after we have gone, so we'll play some music for you so that by the time you come back, if you had put us in Kamoli, you'll find some music playing, but the speakers will be gone. Thank you so much, ladies and gentlemen.